Hypocrisy.
Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. Let's get rid of this banner. This is not accurate at present. What is happening? What is happening over here? I think I need to get this jacket taken in just a little bit. Just a little bit, which is annoying. It's annoying to have to get a jacket taken in a tiny amount. Anyway, I like it though. I like this jacket. I just got it. Just got it. Doesn't matter. We have Kelsey Fitzsimmons, day 4, closing argument. Hair on the other hand. I know it's just a disaster. I need to go in and get some things trimmed up. What is this guy doing? Just hanging out? I need to go get some things trimmed up. But until then, it's going to the moon. It's going to the moon. All right. Closing arguments, day 4. I've got them ready to go. They've been going for a little bit, of course. I am late this morning. Sorry I overslept. Who knows? When I want to wake up, don't wake up. When I want to sleep in, wake up at 5 in the morning. Cool. Thanks. So nice. Racist sleep or whatever. I don't know what to call it. Right before we get started, let me just, I realized that okay, I gotta start the stream on Rumble Studio. It's like the same thing. We do already have a super tip, which is beautiful.
Wake up, Nicker! Micropene!
Oh my goodness. Let's see. Did I tweet this? I think I tweeted this. Okay, so Rumble Studio's going. I need to get the Rumble chat up. I need to get the correct Rumble chat up for me. And why does it do this? I don't get it. Pop out chat. Here we go. That's all I wanted to do. I just wanted to pop out the chat so I can move it over here. Backwards ass situation we have going on there. Stop the chat on locals. The Rumble chat's always on screen. Once I transition, which we can go ahead and do like right now here. Although it looks like 1 second, I gotta fix the proof of life. Is that what I want? Hold on. I gotta make sure I'm on the right. Fitzsimmons trial, day 4. Nope, not that. Not that. This one. Okay, this many. And then I have to move. What is all this extra work I have to do reorganizing my OBS? Stupid. Okay, there we go. OBS has been properly rearranged. Here we are. Hey, guys. Hello. How are we today? Speaking of transitions, watch this over a break. What is that? Does that have anything to do with this fucking case? Or is it something else? All right. Oh. I guess I should go ahead and write... GG/RL. Man. Have to have a disgustingly sexual super tip. A message for the pin chat. Just a second. And then we can start. Then we can get started. We're going to finish up this trial today for the most part. I have a feeling that we're not going to have like a verdict watch. I think the judge is just going to say, hey, come back at 9 a.m. for my verdict. I think it's going to be something like that. So I think we're not going to be in for the longest, for the longest time. I don't think we're going to be in for the longest time, if that makes sense. Today, but I mean, we're going to have a good time anyway. Here we go. Okay. A couple quick things. Cellulite Podcast says, could you explain deferred prosecution agreement? Is there context to this? Is there context to the deferred prosecution agreement? I don't know. I'll look it up in a little bit and see if there's no context, it'll take me a minute. Monk Insane says, has become a YouTube member. Welcome, Monk. And Fletcher Boy says, Leighton Gay fee. Thank you for that. I'll keep that other one so I remember to go back to it. Here we go. I guess we're going to need some volume boost because these people are absolute rubes when it comes to audio. Okay, I thought I was close. Here we go. Prosecutor is very importantly pulling up his socks. Nothing is happening here. So a really weird thing happens that I'm not quite sure. Kelsey Fitzsimmons' attorney gives closing arguments first. Normally the state goes first.
Hear ye, hear ye, hear ye. All persons having anything to prove before the Honorable Jeff Carter, Justice of the Superior Court, now sitting in Lawrence within and for the County of Essex, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, and this most honorable court.
Ooh, I like Courtney's suit. Damn.
Good morning.
Blue?
2026, Court
Striking.
2, Lawrence Superior Court. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311.
Kelsey's hair's back down. Spiral.
Continued
Like,
jury waive
not
trial.
spiral curls, but like a nice,
Counsel will
nice
please
curl.
identify themselves for the record.
Good morning, Your Honor. James for the President.
Good morning.
God, they're so fucking quiet.
Good morning, Your Honor. Martha Copley for the defendant, Kelsey Fitzsimmons.
Good morning. Good morning, Ms. Fitzsimmons.
Good morning, Your Honor.
Good morning, Your Honor. Timothy Bradle. With me is Ms. Healy, Ms. Hassan, Mr. Leonard.
Good morning, everyone. Thanks. You can have a seat. All right. So you folks ready to proceed?
Yes.
All right. I don't say this for the attorneys who know this, but because the government, the prosecution,
No, I'm not
has
using
the
court
burden,
TV.
they go last. The defense goes first in their closing. And Mr. Bradle, you may proceed.
Thank you very much, Your Honor.
Okay, so because there's no rebuttal, I guess. The state goes first. That's wild. Or am I being crazy? I might be being crazy.
May it please the court. Counsel, ladies and gentlemen. Your Honor, June 30th, 2025 was the worst day in Kelsey Fitzsimmons' life. Her whole world imploded. Her fiancé betrayed her. Her baby was being taken away. She was going to lose her house, her job. It was an incredible confluence of tragedy that was visited upon her that day. That day was about her, and she decided in the midst of what you saw testified to here, she decided to end her life. Patrick Noonan, when he came back up those stairs, Your Honor, walked into a suicide in progress. That gun was nowhere near him. That gun was already pointed at Miss Fitzsimmons' temple by Miss Fitzsimmons. She was a couple steps into the room. Officer Noonan, a gung-ho cop, highly trained, a SWAT guy, he'd already been ginned up all afternoon by the insane, ludicrous statements of Justin Elaine. He had that in his head. He walked in, and like all of us are susceptible to, he made a mistake. He shot too quick. He reacted too quickly. And instantly, he realized that he had to adjust the narrative. And that was easy, to just add 6 words to the equation, Your Honor. He said, words to the effect, "She pointed the gun at me." 6 words. What did those words do at that time period? Those words made him the victim. Those words made him the hero. And those words, most important, made him untouchable. Those words were a defense for his future, his life, his reputation, and they were conveyed to a very willing audience. His colleagues, his brothers, his family, the investigators on the case. So that's really what happened here, Your Honor, and it is a tragedy, and it is something that should not result in any further harm to Ms. Fitzsimmons. This should be over. This should be an acquittal, Your Honor. I want to talk to you about a few of the elements that I know you're going to be concerned about. So, first thing I want to talk about, Judge, is the lack of motive and the lack of intent. Because when it gets down to brass tacks, you know, I know that you're going to look at the law, you're going to look at the credibility determinations, and you're going to make your judgment. And here, this case fails the Commonwealth ship founders on the rocks of lack of motive and lack of intent. Let's talk about motive. Everything in life is motive, and it's ironic that, you know, us lawyers always say, oh, well, you don't need to prove motive, but you really kind of do. It's might not be an element of the crime, but motive is everything in this business, Your Honor. Let's look at the motive or lack of motive. Fitzsimmons and Noonan are colleagues. They have already bonded over shared tragedies, shared experiences. They were okay with each other. They were friends. Kelsey thought well of him, and she thought he thought well of her. She knows he has a family. She knows who his family is. She's not going to harm this guy. She knows, Your Honor, that he didn't do this to her. She knows that Justin Elaine did this to her. And she's, probably most important, she's been in those shoes before, serving restraining orders. She knows she's just a messenger. She knows he's just a messenger. This was the worst moment of her life, and she wanted to end her life. And how did she want to do it? She wanted to do it alone. She didn't want to involve these officers because she knew this was a selfish act. She came in here, and ironically, the most credible evidence that came into this case, Your Honor, was from the one person that didn't have to testify. And she came in here and she chose to testify. And she waived her rights and she testified. And she showed, Your Honor, that she's a moral person. She's a caring person. You will sit down and you'll deliberate, and you'll be drawing the inevitable conclusion that Kelsey Fitzsimmons is a moral person. You have to contrast that with the callous treatment of this case from the other side. Hey, we're going to go serve an order on Kelsey Fitzsimmons. Her ex-fiance got an order on her, on Kelsey. Let's go serve an order. The answer, sounds good. Let's go. Talks to his neighbor. Oh yeah, I'm the shooter. I'm the shooter. She's a whack job. So you have to take these credibility determinations into account. And I know you're a gentleman, but you have to get down to brass tacks on who's who here, Your Honor. What else shows you that she's a moral person? She doesn't want to involve these guys. She's trying to get rid of them. She says, oh, the guns are over here, so she can go where they really are. She keeps trying to give Houston and Noonan baby things to bring downstairs. She's trying to get rid of them. She's trying to get them away from her. She wants to do this on her own. She doesn't want to have some sort of a situation where she gets shot by one of her colleagues and friends. It's understandable because she's a moral person. She waits for her chance. She gets to her room. There's a distraction downstairs. She doesn't know what's going on because she's focused on the job she's trying to do here, the tragic, awful thing that she's trying to do to herself. That's how you know she's telling the truth, Your Honor. You saw in the room, and I'll show it to you in a minute, the chest that she got the gun from. It's a chest on the floor. It has one of those pretty substantial lids that you would have to flip up to get the gun, locate the gun, pick the gun out of the 4 guns, and stand up. If Noonan was standing right there in the door frame, that would have never happened. All those events, that little series of events, he would have been able to stop it. He would have stopped it. It tells you that he's down the steps. He was interested in the distraction downstairs. He saw Kelsey folding some baby clothes, getting baby things ready. His attention, it's human nature. His attention was drawn to go back down the stairs. He walked down the stairs 2 or 3 steps, 4 steps, whatever. And Kelsey told you, straight up, that was my chance. And she took it. And she went in the chest. Exhibit 51, Your Honor, I'll show you right now. She went in that chest, flipped up that lid, got the gun, stood up. She told you, again, she's a moral person. She tried to keep the gun concealed. She made the motion like this, Your Honor, where she put the gun like this, and she kind of walked over here because she didn't want the police to see her with a gun. She held the gun to her stomach area. She walked to a clear area, and she put the gun to her head. And that's what I mean when I say Officer Noonan came back up the stairs.
It's a little unorthodox.
What did he walk into?
I'll give you my
He didn't
thoughts.
walk into some Rambo woman trying to shoot him in the
I think I see his
face.
strategy.
He walked into Kelsey, who you now know a little bit from her testimony. He walked into Kelsey's room, and Kelsey had a gun to her head. And he walked into a suicide in progress, Your Honor. And the man that had just been holding her baby, that she chose to hold her baby, that she chose to feed her baby, walked into her suicide in progress. The gun was nowhere near Noonan. There was no threat to Noonan, and the law says that you may not, an officer may not use deadly force on someone who is exhibiting a danger only to themselves. And that's offered to Your Honor twofold, in the sense that it shows that this was not a reasonable use of force, and it shows you that his knowledge of that statute, as he said on the stand, gives him a motive to lie. He knows that this is not a good shooting. He knows this is not a clean shooting. And that gives him a motive here, Your Honor. And like all of us, we all make mistakes. He overreacted and he shot. He had the look on his face, panic, flustered, he shot. He had made a mistake by leaving her there, walked down the steps, a few steps, and that gave her the chance. And when he did this, he knew immediately, Your Honor, that he had to adjust the narrative. Filtered through the legal lens, Your Honor, that tells us that Kelsey had no intent. She had no intent to harm Noonan. There's no assault here because she didn't have the intent to do so. As the fact finder, you can consider everything I said about motive, that she lacked any motive to harm this gentleman. In fact, it was the opposite. She thought well of him. She knew Justin did this to her. She had just trusted him with her baby, and she had tried several times to get these officers away from the situation. No intent to harm him, no motive driving her mindset to do so. Reasonable doubt, burden of proof, Your Honor. Where the evidence supports a reasonable and more plausible alternative, and that's shown here by Kelsey's testimony, it cannot be said that the Commonwealth has proven their case beyond a reasonable doubt. There is reasonable doubt. When there are two plausible versions of what happened, that itself is reasonable doubt.
Yep.
The versions themselves, Your Honor, show reasonable doubt.
If there
Kelsey's
are two
version
plausible
rings
versions,
true. Noonan's
defendant
version
is
is all
entitled
over
to the
the
one where
place.
they're not guilty.
Noonan's version is contradicted by the strong consensus of everybody else in the house. Noonan portrays a couple different stories, but if you want to pick one where it's this drawn-out potential gun battle, where she's backpedaling, sidestepping, tapping, racking, there's commands going on, that takes time. It takes time for me even to say it. Never mind do it. And that's belied by everything everybody else in the house says. Everyone else says, Kelsey no, 2 shots in quick succession, bam, bam. That does not fit with what Noonan said happened. So on that alone, Your Honor, as a fact finder, I suggest that your duty is accomplished quickly, because there are two extremely divergent versions of this event. And Noonan's version has changed itself. Noonan's version is inconsistent with who you now know Kelsey is as a person. It's self-serving. And like I said, it makes him untouchable. And when you judge it against everyone in the house, he's the only one with the Rambo story. Everyone else has what Kelsey says.
It's true. The Rambo story.
He walks into a suicide in progress. He sees it. He reacts. Kelsey, no. Kelsey, no. Bam, bam. Brain freeze. Mistake. Has to cover it up immediately. What else do we have? You know, when you're a fact finder, Your Honor, you want to look for corroboration. What's the corroboration on either side of this thing? Or lack of corroboration, which is what really it is here. You know, the big one, the big elephant in the room is that this department has no body cameras. We wouldn't even be here if they had body cameras. There's no evidence other than people's words. He said versus she said. That's oftentimes, almost all the time, not a good place to start for the Commonwealth. How many of these guys didn't do reports? What's up with that?
What's up with that?
Why didn't Trooper Strong put the body camera video on the witness he's interviewing? There's no science. The testimony of everyone else in the house shatters his narrative.
We didn't even have science, guys.
Kelsey Fitzsimmons has been blessed. She should be dead 2 times over by her own hand and by the hand of Officer Noonan, who shot too quick. She's blessed. She's here today, and she has a new lease on life. And maybe that's why the investigation is what it is. And maybe that's why Noonan's story is so sloppy, because nobody expected her to be here today, to tell her truth. But she is, Your Honor. And as the fact finder, I want to respectfully ask you to consider the evidence, consider the lack of motive, the lack of intent, the inconsistencies. The credibility contest is firmly in her camp.
I agree.
She came in here and she told you what happened. Unvarnished truth. And I ask you to find her not guilty. Thank you, Your Honor. Thank you.
Short and sweet. Short and sweet. A little reserved, a little unexciting, for sure. To the point, a little bit. Although he started with this appeal to morality. Now, it's a little bit weird in the sense that morality doesn't determine guilt or non-guilt. The law is amoral. Not that it is immoral, although sometimes it is. Not that it's moral. It is unconcerned with the moral question. However, and this is what he was going for, in my opinion, the moral question goes to the likelihood or casting doubt on intent. This is a moral person. And I think he could have gone a little farther with this. I think he could have juiced it up a little bit too. If he would have focused more on the relationships that she had built with the other officers, on her pursuing a law degree, going to law school. We never really heard what happened with that. Maybe she meant she was a criminal justice major. I'm not sure. About her lifelong desire to be a police officer, about her desire to help people, about her descriptions of how she approaches situations. You know, all the facts that she put into evidence about her character, about her perspective, and about the fact that she wasn't there to cause harm to anybody except herself. And she wasn't intending to cause harm to herself when the day started. She only got to the place of causing harm to herself when she realized how fast her life had crumbled. And she believed that it was impossible for her to get back the things she was losing. That was when everything collapsed. But there was no premeditation. There was no desire to cause harm. There is specific testimony to her desire to get away. To not even have the other people witness what she was about to do. To be in private, to die alone. Not to die at the hands of someone else. Not to leave someone else with a trauma or a scar not to leave someone else forced to defend themselves or to be put into fear or apprehension. This, of course, goes to intent and the instructions, the jury instructions that we read yesterday effectively translate to the charging instructions that the judge is going to use. And it's very straightforward. They have to show intent, and all statements, all evidence, everything can be brought in the weighing of that decision. All of it can be considered. Her story about morality, her story about her history, her story about her relationships, all of that comes together. All of that comes in and is actually a part of the record in a factual way. It's been testified to. It's uncontroverted. There's not a counter narrative that she was an immoral person. They didn't have testimony that she was a bad cop. They had testimony that she had had a hard call or two, but that she was being mentored by a superior officer who she trusted enough to hand her baby when her life was crumbling. Maybe even contemplating at that time that she was going to have to die, and she handed him to someone she trusted. That person comes up and blam, 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 blam. Well, actually, no, it was just boom, boom. And then he lied about it. Then he continued to lie about it all the way to today. His lie started the moment he pulled the trigger. I saw someone in the chat say she also lied. You can come out or she also is self-interested in her story, implying that maybe she's motivated to lie. That may be true. Every defendant is self-interested. That doesn't mean every defendant lies. Lots of people are self-interested and don't lie. They have, in a commercial transaction, you're interested in your side of it. Doesn't mean you're lying about it. You have motivation. That doesn't mean necessarily that you do it. But whatever you believe, his motivation to lie started the moment he pulled the trigger and continues through his testimony on the stand. Her motivation to lie only manifests when the state charges her with a crime later, not in the moment, not at the time she pulls the trigger. So, I think Bradel did a fine job. Look, the closing arguments are going to be different because there's not a jury there. Speaking to the things that the judge might find important, that the judge might not automatically consider. The judge might not remember, like in a weird way, he might not remember that he can consider morality and just how much testimony there was. Again, uncontroverted testimony about her morality. They didn't pull that out on cross. They didn't impeach her morality. They didn't impeach her relationships. They didn't do any of that. Nothing at all. They did impeach Noonan. I'm the shooter, I'm the whack job. He brings it up here. How callous. Almost braggadocious to his neighbor. I'm the shooter. She's a whack job. It's inappropriate. If nothing else, you know what that looks like? Immorality, poor character. The ex is also sus AF. But you notice what he did? Completely ignored it. Here's why. And this is why I said during the discussion, I said this is a little unorthodox, but I think I know what he's going for. Here's the main thrust of that, okay? You get a lot of yardage already with the judge. You're not starting from the end zone. You're starting way downfield. The judge knows what he's looking for. The judge knows how to review the evidence. The judge doesn't need to necessarily see a timeline, piece together, elements being satisfied or dissatisfied. Like, he knows how to review all that information. Don't sit there and condescendingly tell the judge how to do his job. Maybe point to the things that aren't conventionally thought of as evidence. Maybe point to the things that the judge wouldn't necessarily be instructing a jury on, or maybe would instruct a jury on, but only in limited cases where it might matter. Reminding the judge, hey, you can consider all of this, but stepping back and respectfully letting the judge know that they understand that the judge was paying attention. He was engaged through the trial, and he was involved. When he missed stuff, he asked questions of the witness, which is a cool thing about bench trials, right? The judge can say, oh, hold on, I missed that. Can you go ahead and can you clarify this? Can you repeat that? I missed that. And as a finder of fact, I need to know. Juries don't necessarily get that option. So take advantage of the situation that you're in. And for what it's worth, I think the defense has put on an actual bench trial clinic. I think this is an observable trial for how to learn trial strategy, courtroom demeanor, witness examination strategies being different during a bench trial versus a jury trial. If there were 12 people in that room deciding her guilt, I think we'd get a very different trial, probably much more protracted as well. So I think that's what he was going for. I think that's his strategy. And in that case, I think he did a pretty good job. All around, I think the defense team did about as good of a job as you can do. I think he could have been a little bit more animated on this closing argument, but the gravity of the situation, the appeal to morality, the appeal to character implies he wants to cast an idea of calm professionalism, right? Remember, the state's theory is that she's a lunatic, she's a whack job, she's dangerous, she's got this restraining order, she's pulling triggers left and right, blam, 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 shooting Santa Claus. That's their theory. If he comes out there animated and wild like some sort of fucking ape, it might push the judge's psychology towards that during his decision making. Judges are influenceable by a decision. So like this matters. Blitzen. We'll see what the state does. Blitzen gifted 5 memberships. Thank you, Blitzen. Teeny Cat with $20 super chat. Thank you so much. Says, I'm a truck driver working overnights. Can't catch your trial streams live. Want to let you know your streams have consistently kept me awake enough to not drive off a cliff in the wee morning hours. Appreciate you. Thank you. Thank you. And please stay on the road. We appreciate you being alive and the people around you being alive as well. Chipper Jones. I can't see Jew Walsh in chat. Please help. We are in love. You got to open your eyes, man. Open your eyes. Senile Zeke says prosecution stated they have 16 in the mag, 1 in the chamber with a 16 mag capacity. If she racked, there would be 15 plus 1, meaning she didn't rack. Correct. She never, like they said when they retrieved the gun from the safe, there was an empty chamber, 1 loose round in the safe, full magazine. Not 15, not actually 15 in the mag though. I think it was a full mag if I remember right. Now you can manually load in a round. I guess. I don't know why you would. That was a little bit... That one didn't get explored too much. Okay. Where's Bronca here? Well, I think he's on his own show. I don't know. This one, yeah, he might have actually liked covering this trial, especially because it's so short. The days aren't... dragged out. All right, let's see what the state's got. Guys sucks. The state attorneys. We had one micro peen already. Yeah, and there was a judge. Thank you for my cat type this. There was a judge instruction, no character assassination, or we're not going to do that. He said, we're not going to do these big character assassinations. Which I think matters quite a bit.
If I may?
Yes.
Every piece of credible evidence in this case proves one thing, that she's guilty.
What?
All the testimony, the
Wait.
scientific evidence,
Huh?
the physical evidence, the demonstrative evidence, everything points to one conclusion: she is guilty.
Overselling it.
Even her own testimony proves she's guilty. Because it's impossible to have happened the way she said it.
Wait,
It is
what?
Scientifically, mechanically impossible for it to happen the way she said
Where
it.
was any testimony about this?
Her story is that she grabbed a gun, put it to her head, pulled the trigger, and it clicked. The chamber was empty. That's what her story is. And that's what Officer Noonan's story is, too. She pulled the trigger, click, nothing came out. There wasn't a round in the chamber. She even said she told everybody how stupid I am. I tried to kill myself with an empty gun. But what do we know about the gun? What do we know about her gun? Because after she went to the floor, Lieutenant Dave picked it up, put it on the bed. Officer Noonan picked it up and put it on the table. And then Officer Kaur came in the room. And what happened then? Officer Noonan said, secure that gun, make it safe. And so what did he do? He took the gun, he found that black box, the safe. He made sure that was empty, he turned it over. He pulled out the magazine that you can see right here. He opened the chamber, and there was a round in the chamber. He dumped it out into this safe and put the firearm in there. And then they stood watch on that until State Trooper Bonasara.
I actually don't remember that testimony at all.
That magazine that you have in evidence contains 16 rounds. It was a 17-round capacity gun. It contained 16 rounds, plus the one that was in the chamber. 17 rounds. As we know, there are only two ways to get a bullet into the chamber. One is if there's already a bullet in the chamber, someone pulls the trigger, a bullet comes out, the casing comes out, the chamber's open, the spring allows another bullet to come up. That's one way, and we know that didn't happen here. The gun didn't fire because the chamber was empty. The only way a bullet gets in this chamber,
We're going to have to go back
other
and
than
check that
way,
guy's testimony.
is if someone racks the gun. She said she didn't rack the gun, but there was a bullet in the chamber. She did rack the gun. What did Officer Noonan say? She pulled the trigger. Nothing happened. She stepped back, tap racked, tried again, didn't do it. Tap racked again, pulled it, and that's when he fired. She put a round in that chamber. That's the only way it got there. Her story
Actually,
can't
it's
be
not
true.
the only way it
She
could
got
get
up
there.
on that stand and she lied to you. It's scientifically and physically impossible for her story to have happened the way she said it.
Is that going to dual action?
That's what the evidence shows. But she didn't just lie to you then. She lied again. She lied at the scene about where the guns were. And I'm not, and she admitted that, and I understand that, right? And she said she lied to the police because she decided to kill herself. But when did she say she said that? They had been to the house. They had talked to her, according to her. She now started contemplating all of the ramifications of what's going to happen to her. Because she's losing her life, her job, her son is being taken away, all of these things. And so she's going that over her head.
I know dual action
And then
refers to
minutes
hammer.
later, as she's walking through the house,
If she had half-racked the gun,
she says, "My
that
gun's
would
in the
explain
basement,"
why when she
because
pulls the
that's the
trigger,
time she made the
the
decision
hammer clicks on an
to
empty
kill
chamber.
herself. Later
Otherwise,
on.
how's the hammer click?
And we know that's a lie. We know that's a lie because what was one of the first things they asked her when they went to that house? They asked her
I'm
to put the
missing
baby
something
down because they were concerned
very
for the baby.
possible.
Told her the restraining order, what the parameters were, and asked where your guns are. When she was still sitting on the sofa. They weren't waiting to ask that question until she was already walking around the house. No way. And what did she say there? They're in the
Locks
basement.
don't have a hammer.
And we know she said it there before she moved around the house, which is untrue, because her friend, Officer Houston, who was invited to her wedding, says it also. He says, Sergeant Daly asked. And then remember what he said? He said, I was in the living room, she was sitting down, and then I saw a gun case on the other sofa, and so I opened it up to see. And she said again, I already told you the guns are in the basement. Now, why at that point did she say that? We don't know.
We
She
do.
didn't tell us, because she lied to us about why she said it
No, she
later.
did. She said she was trying to
We
get
know
everyone
she
away
didn't
from
say
her.
it later.
So she'd go
So
upstairs
she
and
lied again.
plug herself.
You can't trust her. She also lied about knowing that her mom was in the house. She was upstairs. The officer, Noonan, I think it was, Noonan heard an older woman's voice down there and said, who is that? She says, I have no idea. She doesn't know her own mother's voice, her best friend that she just talked to come to the house. And she said she didn't know whose voice it was. Another lie. She said on the stand yesterday that she didn't know Justin was in the house. And we know that's a lie too, because what happened when the three of them were upstairs? It's Noonan, it's Houston, and it's the defendant. She hears him downstairs. Houston hears him downstairs, and she says, keep him away from me. I don't want him in my house, or something to that effect. And that's when Houston went down to make sure he wasn't coming up and went to the basement. She knew he was in the house. She absolutely did, and she lied to you when she said she didn't yesterday. And you know what else
No, she
lied
knew
about?
he was there.
Something so simple, but it shows who she is.
She didn't know he was
the
in the
restraining order.
Keep him away,
She
keep him out of the
said the
house.
restraining order was taking my dog away. It says it. It doesn't say that. Nothing about the dog in there. I could go on about the lies, but I want to talk about the credible evidence.
Why didn't you
The
cross-examine
credible
her on
evidence
that then?
In this case. When Lieutenant Daly got a call, I actually got a visit from Justin O'Lane when he was in the lobby of the PD. And Justin told him he got a 209A against Kelsey Fitzsimmons. And Detective Daly knew that she had been sectioned before, that she had guns, that they were taking the child away from her for a period of time. And so what did he do? He called Officer Houston. He asked Houston to call Daly to meet up. And why did he say he did that? He said because those two are cool, calm, and collected. They don't panic. They keep things calm. That's what he said. And that's why when he called Houston, he said, can you call Daly, we got to do this. And so he wants you to believe, defense counsel, that Pat Noonan was cavalier about, oh, okay, sounds good, we have to serve a restraining order. But that's not what happened. He was mischaracterizing it, I hope you remember, in the grand jury minutes, because Houston had called Pat and said, hey, we got to serve an order, can you meet me by the school? And Pat said, sounds good. It wasn't until he got over there, it wasn't until Lieutenant Daley was there that they learned really what they were going to do. And they went over there. And defense counsel asked Daley, you guys were cavalier about it, you knew her, weren't worried about the guns, all this stuff. And Lieutenant Daley said no. No. His quote was, we had an increased level of diligence. Everyone was more on point because they did know what they were walking into. They did know. They did know that she had been sectioned before. They did know there was going to be a baby in the house. They did know that she had guns. They did know at that point that she had parked her car far away. This is all going to what they were thinking at that point. They did know all those things. And they did know Justin's concerns. He said, according to Lieutenant Daley, I'm worried she's going to kill the baby, kill herself, and kill someone else. So that's what they were thinking when they went into this house. That's the credible evidence when they went in there. And what did they do when they went in there? They sat her down, and they allowed her, or maybe they asked her, I can't remember, to go around and get some stuff for the baby because she knew Justin was coming to get the baby. And they were in her pocket the whole time. They followed her around the house, at least two of them, while she did that. And you know that because even Officer Houston said, I was in her pocket. We went into the kitchen, and I noticed there were butcher blocks with knives on it. With knives in it. And they were concerned. There was no chance they were leaving her alone. No chance they were leaving her alone. Officer Newman.
No chance they were leaving her alone. Why?
Officer Newman.
Why no chance that they're leaving her alone?
All of the testimony that you've heard about Officer Newman, even from the defendant, he's a gentleman, he's experienced, he is by the book, and his training and experience starting in the military, through boot camp,
about knives in a kitchen for someone who's not suicidal.
Security Forces squadron, with all the training he had, and Humvees and helicopters, and the SWAT team, 2 times a month training, clearing rooms, clearing buildings, hostage situations, missing persons, no-shoot scenarios, twice a month, and a 40-hour block every year. For over a decade he did that. And he moved to Lawrence, as far as the department goes, because it was busier, and he had more experience. He was cool, calm, and collected. There's no doubt about that. And to say when they're upstairs and he walks away and leaves her alone because he heard a commotion that Officer Houston was going to attend to is a joke. It really is.
Oh. Everything else they did was by the book.
At that point. And how do you know they were vigilant?
Like bringing Justin along.
Because they followed around everywhere. Because both Houston and Officer Noonan said she kept handing us things, and we kept putting them down. We wanted our hands free. Because they were ready for whatever happened. Hoping nothing did, but ready for whatever happened. So at some point, Houston and Noonan are upstairs, and the defendant goes into her room. And she hears Justin, and Houston goes down to keep the peace to make sure he's there. And Officer Noonan is watching her. He's watching her. And she's on one knee. And she lunges, and she disappears. And she emerges with this, pointing at him like she is trained to do. Click at his face. And what does he see next? he draws his weapon, and he says his testimony, it kind of slowed down. The whole thing took maybe 4 seconds, maybe even 3.5 seconds. His training has kicked in. His experience has kicked in. It was a surprise to him, certainly, because she got the drop on him. And why did she do this? Who knows? Maybe he's right. Maybe she was going through him to get to justice. Maybe she was just so upset she was going to shoot anybody in front of her. Maybe she wanted him to shoot her. We don't know because she lied about it. We don't know. But the fact is, she started to shake, she started to tremble, and she lunged for the gun that he couldn't see. And what happened after she clipped? She stepped back, and now he knows, based on his training experience and the clip, there is not a round in the chamber. He knows that, and so he doesn't shoot. According to the defendant's testimony, he had every right to shoot at that point. And you know what? He actually did. He had a right to shoot her at that point. If you point a gun at a cop...
How does he know there's not a
and pull
round in the
trigger,
chamber?
They get to shoot, but he didn't. Because he was controlled and disciplined. That's the way his career went. And so she steps back, tap back, and tries to do it. He doesn't shoot her then.
Because of the
and what's he
click,
doing at this
how?
point? Kelsey, no. Kelsey, no. Because he knows the threat isn't there, really, because there still wasn't one in the chamber. Kelsey, no. Kelsey, no. He is being disciplined like we wish every police officer, every law enforcement agent in this country was. He should be applauded for his actions on that day.
In fact, he's a hero.
Tap rack again.
She wasn't even black.
Now he knows one's in the chamber. Threat's on. She starts to raise it, and he shoots. He shoots twice to stop the threat. He stopped shooting when the threat was neutralized. Defense counsel, during his cross-examination, well, you would have unloaded her gun. He goes, no, that's not what you do. You shoot until the threat is neutralized.
That's
now down
literally
on the
the
ground.
opposite
But his training and
of how they're
experience is
trained.
still taking over at this point, because what does he do? He still has his gun on her, because the gun's still there. He can't see it. Lieutenant Daly comes in, Lieutenant Houston comes up, and what does Officer Houston say that he sees when he comes upstairs? That Officer Newman is standing there with the gun low and ready. His training is still taking place. He's still doing what he was trained to do. The gun is put on the bed. He's calm and collected. He takes the gun and moves it away so people are safe. He's deliberate in those actions. When it's away from her, he starts to tend to her. Officer Core comes in, and he asks Officer Core to make the gun safe. He's cool, calm, and collected. That's what Lieutenant Daly
cool, calm, and
expected,
collected, but he
that's
shoots a
what
fucking
he
air
was.
conditioner.
He didn't make a mistake. That's what the credible evidence shows. And what did he say to Officer Houston after? And this just goes to state of mind, I know. That she pointed the gun at me, and it clicked. And she tried to rack him up. Immediately after, this wasn't him saving his hide or protecting himself. Seconds after this happened, that's what he said. Every piece of credible evidence points to the unmistakable fact that she was guilty.
Unmistakable.
Every piece of physical evidence, scientific evidence, mechanical evidence, every piece of testimony from Daly to Houston to Core, even Lauren Page, the mother, even the defendant corroborates what Officer Newman says. Every piece. Your Honor, I would suggest to you there is only one fair and just verdict in this case, and that is guilty. Thank you.
May we approach sidebar?
I'd like to speak with counsel anyway at sidebar for scheduling purposes.
Okay, Bradel says we need to go to sidebar. I think Bradel is a little bit. Now I could be way off on this. Look at his face. We only have.
May we approach sidebar?
Hold on just a second. I know it's not much. That posture is hostile, frustrated. To me. He's pissed about that narrative. Something in there really bothered him. And I think he's right to be. I think he is right to be angry. I think homegirl over there just misrepresented some evidence.
I'd like to speak with counsel anyway at sidebar for scheduling purposes.
Yeah, Courtney's suit is fantastic. I like Kelsey's sweater. Her blazer and pants were like neutral. They look good though. She looks good generally in court. She wears her outfits well. I don't know. I guess I should do a little summary of that closing argument. I thought it was a little slimy. I think it misstated or misrepresented at least some of the factual realities of this case. He said things that were not true, like she never explained X, Y, or Z, but she did. She did explain that she was going, she was going up to kill herself. He stated things about law enforcement procedure, about the evidence, and about how guns work that I don't feel we actually got sufficient testimony on from recognized experts on those issues. Personally, he had his own narrative and he had his own facts. Some of the facts I don't remember, and that's perfectly possible. Perfectly possible that I just missed him. That happens plenty of times. But man, we're gonna have to go back and check out some of these moments, especially the testimony about the gun. I do not remember the testimony going that way. I saw a lot of people in the chat saying the same thing. And so but that's entirely possible that I just missed it. But there is another way that a chamber gets into that round. And it's if any officer involved racks that gun after she's shot. Either. There's no body cam. Noonan could rack the gun before the guy gets up there. The guy coming up the stairs, he could see it. He could look at Noonan and be like, what the fuck did you do? He could rack the gun. Criminally confident. I don't know. So it's cheap. That's the crazy thing. Like, not cheap. It's not an expensive jacket. But I guess it's not cheap. It was right. I buy a lot of suits from this place, so I got a deal on it. It was $170, I think. Whatever material it is, it's not like wool or whatever. They actually apparently print the pattern on the jacket, so I'm kind of interested how that works out, like durability wise and stuff. But it's a relatively new thing. It's super light. It's stretchy. It's very comfortable. So we'll see. We'll see how it goes. But I definitely like the look of it. The feel of it's amazing. It is light. I'm not like melting hot. And I think I need to get it taken in about an inch though. I love to take in inches. You know what I'm saying?
Council table.
Let's see what.
Council returning to council table. I'm just going to. We went to sidebar for
I'll
two
check the
reasons.
material
One was Mr.
in a
Bradel
second.
has a series of objections that he'd like to lodge about the Commonwealth's closing, which
Yes.
I'm going to give you an opportunity to do in open court.
Hell yeah.
With the Commonwealth in open court responding.
100%. I thought, sometimes you go, am I crazy? Am I crazy? Did I just miss stuff? No. He had a bunch of objections, a series of objections about the state's close that he wants to levy in open court. Doesn't matter if he wins these objections. These objections are to let the judge know that's some bullshit. He just said that's some bullshit. And that's what matters here, because the judge isn't going to decide the case on these objections during close. He's going to say, okay, I can account for those things. I can strike that, or I can ignore that. I can factor that into my deliberations. So he's probably just going to, let it all go. I don't think you're not really going to get a mistrial here. But the prosecutor or the defense attorney is like, that was not what happened. He misstated the evidence. And we know he misstated the evidence in one place, that 100% misstated the evidence when he said she didn't explain to us why she did this, why that statement was made. And it was, no, she did. She very specifically addressed that statement and said it was because she wanted to kill herself. I don't remember what the statement was, but he said she never explained that. And she absolutely did. You could disagree with her explanation. You could not believe it, etc. But she addressed that. For him to misrepresent that is improper. Whatever else, we'll see what objections Bradel has.
And also.
Oh, real quick. Let's see. Chipper Jones says, please check DM from Chipper Jones. Jew Walsh found and sent you the RO affidavit, and I sent it to you too. Great find by Jew Walsh, to be honest. I'm being asked if Jew Walsh was banned for some reason in the chat. I'm not aware of that. I'm checking into it right now. It's annoying to like, YouTube doesn't have a good way to look, like the ban list sucks. And so sometimes it's hard to find people, but I'm going to check that and make sure Jew Walsh is not banned. If Jew Walsh is in the chat and just maybe not chatting, please go ahead and speak up. There's no reason she would be banned in this chat unless there was a mistake. So, or someone acting nefariously. So if that happened, we'll get that fixed right away. But I just had some questions about it. But yeah, we'll the link that they have is to the restraining order. We're going to check out the restraining order, and apparently that restraining order affidavit has been produced. Mrs. Domestic says, sound logic says she gains literally nothing for killing him, but gains what she wants in her story to escape the pain. If you've had SI, you get it. Yeah. Again, the motivation, I love how Bradel classified it as the Rambo story, because that's the story that they're trying to go to. That's the story they're trying to go to, is that this is some sort of Rambo event. She's about to murder everybody. And that's insane. What's the motivation for any of that? What is her motivation for threatening Officer Noonan? It's to get past him, to get downstairs, but she didn't need to do that. Like, she already had, like, didn't they testify she already had the gun on her or whatever? All this stuff, their stories just don't add up. But the story of her wanting to kill herself and get away from the cops to do so she could actually carry it out, that does add up. She knows that if she pulls the gun in the room, I mean, she'll make them react to the gun reacting to the gun might be them going, like if she's putting the gun to her head, it might be them tackling her and stopping her from killing herself. But shockingly, people who are killing themselves, especially with a gun, usually want the job done. They don't want to be stopped. Yeah, criminally confident. Jew Walsh was, she was very active yesterday, so I'll check. And if she can hear me or whatever, DM me on Twitter if you're like actually watching and stuff. It'll help me figure out what's going on. But no, there's no reason she would be banned from this channel. I think she's hilarious. And then Aaron Burr sent Nick day 2, 2 minutes or 2 hours, 32-minute mark is testimony about emptying the gun. We'll watch that in just a minute. Here we go.
So I went over the schedule. So as I told counsel, my intention is to take as long of a period of time as I need to reach a verdict, provide the court staff and counsel with 30 minutes notice, and come out and announce my verdict, some of my reasoning here in public, and whatever time that works. In other words, if it's during our traditional lunch break, so be it. You folks will have a half-hour notice, which means that you'll be able to go and have coffee or lunch or whatever, as long as you can get back here. All right, so that's how we've worked that out. We also discussed at sidebar the fact that in a jury trial, we never provide the jurors with ammunition and a firearm, even with the trigger lock, at the same time. So my intention is that Mr. Ruane, our assistant clerk, will keep possession of the ammunition, and the firearm will come back in chambers with me, along with the other exhibits. When and if I need the ammunition, they'll be switched out. All right. Okay. Globally, have I discussed have I said in open court what we discussed?
Yes.
Okay. All right. So, Mr. Bradel, I'll hear you on the objections.
Thank you, Your Honor.
Here we go. Time for the objection.
So, Judge, traditionally we do this at sidebar, but as you mentioned, we don't have a fact finder here that we need to talk off to the side to. So, in open court, I'm happy to do this. Sure. Yep, I'll go back over everything I said at sidebar, Your Honor. Judge, the first objections I have to counsel's closing argument center on ballistics issues. The first part is that counsel picked up the gun and used it 3 times. Prior to that, counsel provided what I would consider to be expert testimony on the operation of the gun. I think it exceeded the scope of what Detective Bonasaro talked about. He said that it had to be a scientific certainty that this gun was racked by Kelsey Fitzsimmons. Mischaracterizes the defense position that we're not saying necessarily that it did or didn't happen. We said that Kelsey Fitzsimmons didn't rack the firearm. And we have a completely different version of events. So no one's saying that it didn't happen. We're saying that Kelsey didn't do it. And to characterize it like, that it had to be racked by Kelsey Fitzsimmons is not fair argument, and it mischaracterizes the state of the evidence. The second objection relative to ballistics, Your Honor, is that counsel was acting out. I believe it was the second time he picked up the firearm. Counsel was acting out on Noonan's story that Ms. Fitzsimmons had accessed the firearm from the chest and picked it up to point it at Noonan's face. And on Noonan's testimony, she just pulled the trigger and it clicked. Counsel's acting it out. Prior to pulling the trigger, counsel racked the firearm and then pulled the trigger. And that's not what happened on even Noonan's testimony.
I'm happy to allow you to make a record, but the fact that there's 2 different versions of what folks testified about is fair game. What the issue right now is whether the Commonwealth argued items that were not in evidence or attempted to draw inferences from items that were not in evidence. So the disagreement about the racking is just not before me.
Well, that's why I bring it up, though, Judge, because this racking issue has been brought up to the forefront, and he did something that is not part of the evidence. No one says that she racked the gun before the first shot, and that's what he did when he acted it out. So that's why it's a mischaracterization. I'll just rely on Your Honor's discretion.
But that's not what Mr. Kubatosi did, though.
I did see him rack the firearm before he fired the second shot. He did it the second time, Your Honor.
Okay, I'm having trouble understanding. Again,
it's just that when you act out the testimony, you have to do it accurately, and he didn't.
I'm going to say this in open court, and it won't be the last time I say it. Whether or not Officer Noonan exercised reasonable use of deadly force is not before me. That is not my decision.
I agree with you, and I say it on credibility.
And hold on. And whether the North Andover Police Department followed procedure in executing, serving this restraining order is not before me. Child custody is not before me. All right? Visitation is not before me. What's before me is, has the Commonwealth proved beyond a reasonable doubt that the defendant pointed that firearm for any perceptible amount of time at Officer Noonan? Okay, so all of this is just not helpful.
No way.
I offer credibility, though, Your Honor.
Okay.
Also, the Commonwealth said that on the scene, Ms. Fitzsimmons didn't say part of her story there, so therefore she's making it up. And whenever the Commonwealth tries to argue that somebody, a defendant, didn't say something, that's very dangerous ground for the Commonwealth, Your Honor, that the defendant is under no burden whatsoever to say anything, Your Honor. And here, to suggest that she's lying because she didn't say part of her story when she's shot in the chest at the scene is unfair argument, but it also violates her right to remain silent. And it's an intrusion on that, so I would object to that. I ask you not to consider that, Your Honor.
Except that, Mr. Bradle, she waived her right to remain silent, right? She testified. So
at the scene, though, Judge.
Isn't it fair game for the Commonwealth to discuss the testimony that your client offered?
The testimony, yes, but he's saying that at the scene she didn't say XYZ when she didn't have to say XYZ at the scene. And that's, the Commonwealth can only argue that when a defendant makes a comprehensive statement and leaves something out.
Yep. Whoa! What? The fuck just happened? It'll be right back. The feed died.
Which didn't happen. That was not the statement. So that's a very important, very dangerous, very unfair, very prejudiced. So that's a
Jew Walsh has been restored.
to my client that she wanted to kill someone else, which didn't happen. That was not the statement. So that's a very important, very dangerous, very unfair, very prejudicial misrepresentation of what was attributed to Justin Elaine in the lobby. She never said anything about killing someone else. He didn't even he didn't say that she said that. So I ask you to strike that and not consider it.
Real quick. He said, Mike can't type this, says, having second thoughts about the judge. I understand. Hear me out, though. All judges do this when they are the decision maker, when they're the fact finder, and judges are decision makers and fact finders a lot more than we give them credit for. Bench trials are rare. But judges conduct evidentiary hearings without juries all the time. They do either family court, juvenile court, stuff like that. Those don't have juries. But also just motion practice sometimes has evidentiary hearing requirements that go on, including, for example, in Minnesota, your Rule 11 omnibus hearing is your opportunity to challenge the sufficiency of a warrant or any other dispositive pretrial motions. Well, some of those dispositive pretrial motions and the sufficiency of the warrant require the collecting of evidence, and sometimes that evidence is testimony. So the judge hears it. They don't panel a jury for that hearing. The judge hears that. The judge becomes the fact finder and the lawgiver, right? In the same breath. And that's very common. They're practiced in this, even if they don't do a lot of full-on bench trials. All judges believe that they are able to individually section out evidence in their very erudite and astute minds. They can't. All of the science in the world says that people cannot ultimately and definitively determine their own decision making and what goes into it. They can make reasonable efforts. They can try really hard. Some people are better at it than others. They can compensate for it, but they are not aware of the things that are influencing them, which means they are not aware of how to properly remove the things that are influencing them. And by they, I mean every single human on earth. Only all of the science suggests that this is true. We just do not have the capacity to do that. Our brains function too autonomously, beyond our own consciousness. They collect and gather and collate information and store it in different ways and apply it in ways that we're not conscious of. So we can't be aware of how to rule out subconscious bias. But all judges believe that they can, every single one. This is not abnormal for a judge to do this. And I think he's saying, this stuff isn't before me. I don't care about this. Bradel properly and politely and professionally corrected him. He said, it goes to bias, Your Honor. It goes to, not bias. It goes to credibility. And that's why the state brought it up. And he doesn't want to leave that lingering. He wants the judge to consciously as possible, remove that because it does go to her credibility. But the state did lie. They manufactured evidence. And that goes to their credibility. Him saying that is really, really important to do so. I don't think it says anything negative about this judge. The judge's actions and responses are entirely within the realm of how judges do things, if that makes sense.
Much like Officer Noonan, I was also Macy Twat Team, 3rd Infantry, Umpteenth Division. Once sniped a shoplifter from 45 yards with an airsoft.
Very good. How'd that go? Sledge Entertainment says, sorry, Nick, I'm late. Not gay. I'm on lunch break from building a Baldo that fits micropeens. From building a Baldo that fits micropeens. Hope you're having an awesome day. I think all Baldos necessarily fit micropeens. Like there's nowhere for the penis doesn't go inside the ball. I don't want to talk about this. It doesn't go. It's on the outside, like Aaron Lewis. Speaking of was on the outside, I guess. I don't know. I checked the ban list. Couldn't find Jew Walsh on the ban list. But I just went ahead and added her to the approved user list to figure out. I don't know. Like there's a thing that says these people are good. So I just added her on there. She's been awesome. Very funny. Happy to have her in chat. Jew Walsh gifting 5 memberships, of course. Thank you so much for that. We'll get that updated, but whatever the issue was, I have no idea. I have no desire to ban people. They have to go pretty far for that to happen, but it is possible that like a moderator fat fingers something or something like that. I didn't see her on the ban list, but I obviously want to rectify anything like that. If that ever happens, guys, reach out to me because if you think that you were accidentally banned or banned improperly, or if you were banned like a long time ago and you're like, hey, I was, whatever, it's likely I'm going to bring you back if you just reach out. Like, I don't have a desire to keep people away from the show. Jenny LJ gifting 10 memberships. Thank you, Jenny. I appreciate that. So awesome for you to do that and share that lovely member juice with your fellow chatmates. We love memberships. Okay. So guys, another thing, we're going to get right back into his thing, but while I've got it paused, Megan Fox wants me to watch this hearing in the Laura Owens case. It's the Tonsil twins. I think it's about her lawyer, David Gringus, and maybe some disciplinary stuff. She says it's really funny. Do you guys want to do that later? We can do that in a minute. Like when this stuff's done, because this is going to be an early day, I think. I'm going to go to the bathroom while you guys mull that over, and then we'll get back to these objections. Okay. Here we go. Here we go. Art the Clown's usually only available at night. Jobs and stuff. Okay, here we are, guys. Back to this.
And the last thing, Judge, about lying about the dog on the restraining order, Your Honor, that trying to take her dog. And it is in the complaint to the restraining order by Justin Elaine.
I know he's trying to do a second closing, but the evidence is what the evidence is.
Yeah, but Judge, you can't say, when you have the discovery on the point, you can't say that something is a lie when you have the papers that show it's not a lie. And the box was checked.
That was real shitty of the state there to object during this guy's allowed open court speaking objection that he is going to get to openly respond to. For him to object during the objection is bullshit. Absolute cockbaggery. Here's the problem, just so people know that I'm unbiased. I'm not. I want Kelsey to win. But in an unbiased attempt, a reach out, Kelsey testified that she wasn't aware of what was in the affidavit. Now, very simple. If they say we got to take the dog, then she knows that they're taking the dog. Like if they just take the dog, that's it. But Kelsey testified that she didn't know what was in the affidavit, the restraining order affidavit, at least at the time. So if The dog taking is in the affidavit. She doesn't learn it from there. But it doesn't matter, does it? If they're taking her dog, they're taking her dog. And there's a reason they're taking her dog. This is actually really obvious if anybody thinks about this at all. She's getting Section 12. She knows she's getting Section 12. 72 hours. It's a 5150 in other places. Section 12, she is getting sectioned 72-hour psych hold because of what's in the RO. That dog has to go somewhere or it'll die. I mean, a dog could probably live 72 hours without food and water, or it can maybe find something around the house. Like, who knows if she has like leftovers out that it would get to in an emergency or something. But 72, they can't leave a dog there. They'll potentially put the dog in harm's way. So the dog is got to go to someone else's place. Like, it just has to. So even her dog is probably going to get taken away. She won't know when she's going to get it back or how. So anyway, we will look at the restraining order affidavit. That's now been, I wonder if that's been released because of what happened here.
In the complaint to get her dog. So that's a mischaracterization of the evidence that needs to be corrected, Your Honor. And that's my last point. Thank you.
So
Peachy says, I thought you can't be a cop after Section 12. That's another thing she said in her testimony. I know that after that restraining order, if I get sectioned, I'm losing my job. I'm losing my baby, my house, my fiance was the next one, my house, my little doggy, probably my job. Even if she kept her job, she thought she was losing her house because she lost her fiance and they needed dual incomes to pay for the house.
Commonwealth, from my perspective, with all due respect to Mr. Brado, who's done a terrific job advocating for his client, I view that as nothing more than a rebuttal to the Commonwealth's closing. So I'll give you a few minutes to rebut these things. Let me say this, though.
I disagree with that by the judge. I think those were proper objections, and they were sound. I know the judge says, I'm not considering that. That's not before me. But if that's not before you, it doesn't belong in closed, and there should be no problem striking extraneous statements made during close from the record. He's regarding it as a rebuttal. I don't think it was a rebuttal at all. I think it was very much specifically objecting to the improper use of evidence by the state. We all felt it. We all felt it collectively. Our balls hummed at the same time, in unison. Our power levels rose, and we're like, nope.
I don't believe that there was any evidence before me that Miss Fitzsimmons was sectioned previously. I think that the way I view the evidence is that this is what the police believed. It was part of their state of mind in serving it. But I'm at a loss, frankly, that, in other words, what I'm saying, Mr. Bradel, is out of all the items that you argued about the Commonwealth purportedly arguing something not in evidence.
Yes, sir.
This sectioning, alleged sectioning that happened prior to this.
Yes.
There's no evidence of that before me. There's
there's no evidence of that before you. Okay, good. Strike it.
There's mention of it, and it goes to the officer's state of mind. So, and that's all that in fairness, that's all that you argued, Mr. Gubitosi. But I guess what I was getting at is if there was anything at all that came close, that would have been it. But Mr. Gubitosi, I'll give you a few minutes for your rebuttal to the rebuttal.
His name is Gubitosi.
I don't think I trust you to have sifted through what's relevant, what's not relevant. The evidence is what the evidence is. Closings are not evidence. I would suggest to you that, I guess I do need to be heard, I guess. That I argued the evidence that came from the witness stand and from the exhibits to Ravanasaro absolutely
Yeah,
described the ways that
That was a specific objection, was that that stuff wasn't in evidence. That stuff wasn't from the witness stand, or it was improperly stated. This is frustrating. I used the stuff from the witness stand. Well, yeah, you can grab a bunch of random words that were uttered on the witness stand and put them together in a sentence that didn't fucking happen. It's still from the witness stand, you dumb bitch. I hate attorneys. I hate them. God, somebody suplex this motherfucker in open court.
a firearm works and how a round gets into the chamber, and I limited my explanation of that to what he described and the like. I don't need to make a second proposal. Thank you.
You just did that.
I did. I'm a lawyer.
Okay. Now,
To his credit, he didn't go overboard on responding to the objection. That's frustrating. That was not a rebuttal argument. If he was going to get a rebuttal, it would have been way different. It would have been much more robust. I think he would have gone and he would have attacked some of the specific things that guy said. But hey, judges control their courtroom.
I respect that on both sides. All right, so at this point, why don't we, I said that I was going to step off for the
You better look me in the eyes when you tell me you respect me, Judge. Then spit in my face and slap me.
gathering of the evidence. Let me not do that. I'd like the counsel to just make sure that all the evidence, the exhibits are in order. You'll note your contentment on both sides. If you folks can take a look at the verdict form as well. I don't know if you already have. It's not complicated, but do you want, Mr. Braille, have you seen the verdict form?
No.
All right, so one of you, officer, do you mind? Officer?
Commonwealth is content with that.
Same,
All right, content with the verdict form, but we're still working on the exhibits,
Yeah,
right?
we'll take a few minutes.
Yeah, that's fine.
The fuck is this? Can't slave. Nick, nobody will respect you when you wear that coat. Don't take this the wrong way. Where do you live? Like not like specifically, but incorrect. Incorrect. You have no idea how much, like I have. We've had so much damage done to men. We've had so much damage done to men, and you guys may think that I'm joking. You may think that I'm kidding. I am absolutely not kidding right now. We've had so much damage done to men by politically interested people on both sides and by the rise of the online simp culture. Okay? I am libertarian. I am not opposed to OnlyFans. I'm not opposed to any of this stuff. I don't care about that. I think the government should stay out of it largely. However, that doesn't mean that there hasn't been damage done. And that damage has been done by hot little bitches who keep telling men that ugly things are pretty, and they're not. Your cargo shorts aren't cool. We were lied to, ladies and gentlemen. We were lied to by women who wanted to extract money while we wanted to be lazy. No! You put those cargo shorts away. You go back to the 70s. You get linen shorts that barely hold your balls, and you wear them proudly to the grocery store. God damn it. Do squats, go upstairs, get thighs and calves like God intended. Women like thighs and calves on men. They like to see them bursting out of shorts cuffs. You were lied to. They don't think your long beard is cool. Oh, it goes to your nipples? That's great. They don't think your fat belly is cool. They don't think your fat man titties are cool. Oh, I like a giant thick man. No, they don't. If he's shapely and thick, yes, you aren't. Your shape is upside down. You're an inverted triangle. Wrong. You say, I have no shoulders? Your hips and belly outdo your shoulders by an Olympic-sized swimming pool length. It's ugly. Some hoe online tells you they like that look. They are looking for your wallet. We have been damaged and lied to. Every day, in whatever way you do it. Dress like it looks like you spent $1,000 on your outfit, and your life will change tomorrow. Tomorrow. You don't have to spend $1,000 on an outfit. It just takes a little bit more time, a little bit more planning. If you can't do it, bring a woman with you somewhere. Pay one. You don't need to have everything you do look a specific way, but stop it with this shit. You have been lied to and broken by women trying to extract your resources from you and an entire industry built around it. They want you slovenly and lazy and unattached so that you will log into a website and talk to a Pajit with more syllables than you can imagine, pretending to be some fiery redhead. Notice how those 26-year-old hotties don't talk to you in real life, only online? That's a lie. It's all lies. They just want your money. They don't want you out in public. They don't want women attracted to you in real life. They don't want you to go to dinner with someone and have them be impressed. They want you rejected because you rejected pays them. God damn it. Get it together, men. Back to the important show. Personal beefs aside. Damn it, I'm banning you, Jew Walls. Get out!
One, contempt of the exhibits.
Yes.
And that would be, for both of you, exhibits number 1 through 98. Correct?
Plus the chalk, Mr. Clerk.
Yes, and the jury instruction.
Thank you.
Yes.
Okay, 98, I thought we had, weren't there 100 exhibits?
No, 98.
Okay, all right. I'm sorry, okay. All right, so, and Mr. Wayne.
Cat slave.
I think
How'd you
it makes
know?
sense, as in a jury trial, for you to swear our court officers in.
Based on the judge's comments regarding the closing arguments, do you think he's leaning one way or another? Based on his comments on the closing arguments, no. I think he had a little bit of a tell. A little bit of a tell yesterday when, after the testimony of Kelsey, he said they were going to go visit the home, and he said, and this is very specific, he said, if the defense even still wants to do that. I think that if there was any micro tell, any break in the judge's neutral facade, I think that was potentially an indicator that he thought that the defense closed it out with their testimony. And I think by the law, by the by or whatever, I think they absolutely did. I think they definitely created reasonable doubt. I think they definitely created reasonable doubt with the testimony from Kelsey, her mother, and the neighbor of Noonan. I mean, the Noonan's credibility was already bad. The neighbor gets the statement in that she's a whack job and I was a shooter. Very callous. Contradicts his mentorly sort of attitude. Although he was trying to distance himself and be cold to her on the stand. He did try to do that. Even though that was sort of countered by her giving him the baby. That was countered by, him apparently mentoring her through some personal issues and some hard calls and stuff like that. Kind of goes against his narrative. But I think they absolutely have presented with the same facts or facts that were not controverted. Because again, anything they brought in their case, the state did not controvert. The state didn't have a rebuttal case. I don't know if the Commonwealth doesn't do that. They didn't have a rebuttal. And they didn't do anything to exclude the evidence that was presented. So we now have evidence. The judge, of course, gets to weigh what's correct and what's incorrect. But we have evidence that is not incongruent with all elements of the story that says there's another plausible reason she had a gun in her hand and pulled the trigger. And it's just that it wasn't pointed at Noonan. It was pointed at her head. I think the only thing that the defense could have done, maybe, and I think that this might have overbloated things and become too complicated, but they could have potentially brought in an expert on how adrenaline can make people have an improper perception. How it's possible. I think they could have done that. We've seen that type of testimony in other cases. Branca has talked about it, but there are experts out there who will testify that adrenaline can cause tunnel vision, can make people perceive something incorrectly because they get so focused on a particular facet of what's going on, like the gun, for example, that they can't actually see how her arms are positioned. They just know there's a gun at head level all of a sudden. But this and this can look very similar in an adrenaline-fueled mind. I also think maybe they could have gotten into testimony about how she was trained if she were to discharge her firearm. Not Noonan, but her. If she were to discharge her firearm, because she's trained to shoot center mass. They don't train cops to shoot people in the head. Shooting people in the head risks missing. Heads are much smaller targets that are more mobile. They're on a hinge, right? Chests, especially hers, am I right, fellas? No, chests are much easier to hit. And there's a lot of vital stuff in there. Heads are actually kind of in a lot of ways, heads are bad targets also because skulls are meant to protect what's inside. And they do change the trajectory of bullets if those bullets aren't in a perpendicular striking wherever they strike in a perpendicular manner. There's a very high possibility that the skull can deflect off or divert the damage away from some of the critical stuff. I mean, you might get some broken bones in your skull, damage to connective tissue or, your hearing, etc. But a lot of times the brain can be protected by the skull because it is a hard surface, and bullets, if they hit at an angle, they skip off. They're moving very fast. They don't turn and penetrate. I said heads are on a hinge. They move. But I think that would have bloated testimony. I think it would have gone too far. I'm just saying that if there was something they could have brought in that would have helped her case maybe a little bit factually or on these issues to further generate doubt about what happened in the room, which I do think maybe there's a little lightness on what happened in that room, but there's only two people who saw it. There's not much you can do. And I think this would have fleshed that out in their favor. But of course, if they had done that, the state would have brought in their own expert to testify the opposite. It would have bloated everything, big mess. So yeah, I mean, I think they've done it. I think they've raised reasonable doubt.
Could you all raise your right hands? Do you solemnly swear that you will keep the court in some convenient place until he has agreed that you will not suffer any person to speak to him, nor speak to him yourselves, unless by order of the court, or to ask him if he has agreed? And when he has agreed, you will return him into court unless the court shall otherwise order, so help you God.
I do.
All right, we will stand in recess for my deliberation.
All rise, please.
Okay, so the court's in recess. It looks like the judge is going to come back at some point today. So I will leave this up. Let's do the protective order. I don't know what she's looking at if convicted. Let's check that real quick. Massachusetts. I cannot spell Massachusetts most days. I don't think they can either. Like the people or the state itself. Massachusetts, assault with a deadly weapon. Assault and battery by means of a dangerous weapon. Mass.gov. Here we go. Reverend John says she's guilty of pointing a gun at a PO. Her, not him. Oh, yes. She pointed a gun at a police officer, just not him. Correct. Thank you. Thank you for the super chat. Very much appreciated. All right. Oh, my God. Assault and battery by means of a dangerous weapon. But this is jury instructions again. Damn it. I don't want that. I want the statute. Where's the fucking statute? Here it is. Give me a second. Here we go. Yeah, I know it's not assault and battery. I assume it's this section covers both assault and battery. I think that's what's going on here. We'll switch things up for a second here. We don't really need to do it that way. There we go. So whomever commits assault and battery upon a person 6 years old or older. No. Assault and battery upon another by means of a dangerous weapon shall be punished by imprisonment in the state prison for not more than 10 years, in the House of Correction for not more than, or state prison 10 years, House of Correction for 20, I think that's 2.5 years, not 21 over 2 years. That would just be 10.5. Or by a fine of not more than, 10 and something else. Don't worry about it. Or by a fine of not more than $50,000, 10.75. Or $5,000. Or by both such fine and imprisonment. So 10 years in state prison, 2.5 years, I guess, in House of Correction, fine of not more than $5,000, or by a fine. So they could do no prison time and just do a fine. If it causes serious bodily injury. This is assault and battery. I wonder if there's, some states combine them just in general. hold on. Let's do this. Charging document for Kelsey Fitzsimmons. Da, 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 da. Go away. Let's see. No, this is about her release conditions. Oh my God, I'm going to lose my fucking mind. Wait, what statute? Let's see. She is... Which one? Assault by means of a dangerous weapon. Yes. I guess it's assault and battery by means of a dangerous weapon. So it is the one... 265-15A. Yeah, this is it. So this is the one. This is the one. Okay, let's find... Where do we have this?
What about the possibility she racked the slide and in doing so caused him to believe she was aiming, flagging his head? That seems possible to me given both testimonies. P.S. Miss your twink shoulders.
They're still there. They're still there. You know, I like this suit. It has basically no shoulder padding. It has enough to, I guess, like box out the shoulder. My actual shoulder is here. It's like a shoe, like your mom pushing in on the end of the shoe. Where's your toe? She did that for me just last week. Why can't you find a link for super tips? It should be just up in the... it should be just up in the description. Let's see. But... Or up in the pinned chat. But I'll send you, or I'll tag you in it real quick. You know what? One thing I wanted to say, there weren't any voices in this courtroom that I like heard anybody say, "Hey, I want that in super tips." Like everybody just sounded kind of normal with a, you know, I mean, they've got a New England accent or sub-Boston accent, but no one really like stood out. Not like the judge in the last in Corey Richins. Woo! Hello. Please remove your pants when I enter the room. That guy he had such a great voice. Okay. Focus, Nick. My God. Very embarrassing. We've got... Here we go. Here's the affidavit. Part 1. Let me zoom in on this. Here is, so Justin, we know. Justin, her fiance, is a giant pussy. We know that. We know that he sucks. And should probably be subject to, you know, female circumcision to close that thing up. Kelsey Fitzsimmons. So this is on or about 6/28/2025. Kelsey Fitzsimmons is a danger to myself and our son, along with herself On Saturday night, June 28th, so he did this. He did this on the day that this allegedly happened. Kelsey struck me with a closed fist 3 times to my face. I was scared she would not stop. When were you scared? I was scared she wouldn't stop. She did it 3 times. Well, I guess that fear was unfounded. My brother and sister heard noise. Like, don't get me wrong. I'm not trying to minimize domestic violence. And I think that domestic violence against men is something that happens and has largely gone unreported or underreported. I think that's changing, of course. And, that guy looks like she could kick his ass. I don't know. I was scared she would not stop. My brother and sister heard noises and knocked. I was able to open the door, and she immediately said she didn't do anything, I think. But then he lined that out. I leaned. He didn't lean. What? Why is there a line here? I feared, grabbed my arm, and she grabbed my arm and ripped me back into the room. Okay, so he first wrote down, she immediately said she didn't do anything. Then he's like, wait, that doesn't sound scary. She immediately grabbed my arm and ripped me back into the room. My brother and sister came in and she said she didn't do anything. Okay, so that happened next. I feared for my life, so I left with a friend to stay at a hotel. No testimony about any of this from anybody. Not a word about this. Let's see. Yeah. I feared for my life, so I left with a friend to stay at a hotel. Family and her closest friends reported that even after I left, she physically hit them to try and get to me. Who? Where? This is crazy. This is crazy. Why the fuck don't we have testimony of this happening? You want to know why, like, right? We all want to, sorry, that was rhetorical. Because this is a lie. Let's see. Kate the Great, 28, says, judge kept all this out due to probative versus prejudicial. So there's an order on this? I think if they could testify that any of this is true, like I'd be surprised on this. I'd be very surprised on that order existing because this would go directly to, if it was true, this would go directly to a lot of state of minds. But it would also raise the question of why Justin was brought in proximity to her. Judge said he wanted to hear about the day in question, not about any of this junk. How can you, like, that's wild. How can you not have the restraining order and the events that are alleged in the restraining order that that's going to go directly to cop's state of mind? Wild. But it is prejudicial and overly prejudicial towards her. I agree. I agree on that. I'm not saying that this should come in, but testimony about it seems like it'd be relevant. I bet they couldn't get anyone to testify to that. Okay, so here we go. She physically hit them to try and get to me. Her friends called the Bethel police in whatever, Maine? What? Methuen police in Massachusetts. I don't know what those words are because I'm not from that area. And North Andover police in Massachusetts because they thought she would try to hurt herself, the baby, or me. Where's all that? Kelsey D. Devon. I don't know what that says. At Zam, while heavily intoxicated, or at 7 a.m. Oh, something at 7 a.m. while heavily intoxicated and fighting her friends, that she would leave to get the baby. Her parents took our son from my parents in the middle of the night, saying they didn't care what manic state she was in. They were taking the baby to her. Today, Kelsey is threatening to take the baby far, far away for a long, long time. This is how she has spoken about killing herself in the past. I fear that she will kill the baby at any moment. She punched her stomach repeatedly. This, of course, she was pregnant, I believe. While pregnant, saying she would kill herself and the baby, she has on several occasions struck me with her hands or feet. I fear if she does not have me, she will kill the baby because she has said nothing besides me as worth living for. In March 2025, she was sectioned by Lawrence General Hospital. This is an ongoing safety concern. So there we go. That is the restraining order affidavit. Decided at 2 a.m. Is that what that was? I believe you. Let's see, what was that? I guess it's decided, yeah. Decided at 2 a.m. His penmanship isn't the worst, but it's not great. So, that's allegedly what happened and why he went for the restraining order. Whether or not you believe that, I can't believe they don't have any testimony on that. Like that blows my mind, because it goes towards the whole thing. But yeah, I see. I don't think I agree with the judge on that ruling. And I'm not sure who that's in favor of, honestly. Because it'd be in favor of Justin if there were people who would testify to this. It'd be massively in favor of Kelsey if there was no one to testify to what he wrote down in the order. You can write down whatever the fuck you want. It's like YouTube chat stop getting fed into StreamYard here. It should, when that happens, it usually picks back up. So we'll see it in a minute. Let's see. Cat Black, thank you. Sent a super sticker. Very much appreciated, guys. We are at 21 members so far today. I need a little bit of a palate cleanser, and I was sent a crazy video of a trans attorney involved in a disagreement with a judge. Does that make sense? Let's see. Hold on, I just have to find it real quick. See, this is interesting. I felt a lot better yesterday than I do after today's closing. I know you guys can't see that. It was just a tweet. It's always interesting to get people's perspectives on this stuff. Okay, so let me... So here we go. This has nothing to do with the Kelsey Fitzsimmons case, but we're not done with the Kelsey Fitzsimmons case. We're going to go back to it. I don't want you guys thinking that I'm done. I'm just going to take a little break and watch something else for just a second. And we'll go back to commentary. Also, if you have any questions, feel free to send them in. You can send them in by Super Chat, Super Tip, Rumble Rants, or always... you can use the free chat, the locals chat, and if I see those, a lot of times I'll grab them anyway. There's no money requirement to talk with me on this show. There never has been. However, depending on things, it might make me see something. So all of those are options, but don't feel like you need to. I will a lot of times see stuff in the free chat.
Is it just me? Or does Massachusetts micro-pen police officers not like mildly attractive white women unless she really is a trained Russian assassin? Let's go, Mrs. Crazy Officer Lady.
Yeah, there's just no way. The state's narrative about what she was up to, as called out in the closing arguments of the defense as this Rambo mode, is so wild. It doesn't jive with anything we know about her at all. V-Sing says judges love to hand out ex parte like candy. Yeah. And I mean, if you think about it, it makes some sense to hand out ex parte like candy because you want the, what should we call it? If someone is in danger, you want the court to intervene. You don't want the court to have not intervened when it's merited. So they default to handing out an ex parte order, and they're challengeable. So everybody's rights are presumably preserved. Although sometimes judges just maybe don't they don't, I don't know how to word it. They just don't give you a hearing. But that's that. Miss Sparkles, member for 1 month, says, loving the suit. You're in your glow up phase. I can't pull it up because, YouTube is like not connected down to, or the chat is not feeding into StreamYard. Like I said, happens on occasion. It'll come back. For now, let's do this. But thank you very much, Miss Sparkles. I couldn't hear any of that, although that's probably because we have an insane person screaming. I can't breathe. Put your hands behind your back. I cannot breathe. You know what I'm going to do for this to make it a little bit bigger? Just give me a second. Let's, hold on. I don't want that. I keep doing that. Okay. Clean that up a little bit. Clean that up just a hair. And, oh shit. No, there's a reason that I did that. Never mind. There's a reason that I do this. I forget. It's because we have vertical mode going. And that sucks for vertical viewers. Go away. I'll make this. Go. I'm going to lose my mind. Ah! Stupid Twitter. Stupid Twitter. Hold on. I just need to move something real quick. I think we can make this dumb. Make it kind. No. Perfect. That's the maximum I can do, which I think is what I had already had.
I pointed you to the exact paragraph.
Stop.
It's her education.
Stop.
Stop.
Okay. You can already hear it, right? I pointed you to the exact paragraph. This is about education. Okay, cool. So this attorney is allegedly trans. The judge is like, knock it off. I don't know what the attorney is trying to educate the judge on, but probably something hilarious.
Oh,
The
stop!
argument is.
Stop! You interrupt me one more time, you are being held in direct contempt of court, and
Yes,
you can
ma'am.
wipe that smirk off
I don't
your
have a
face.
smirk on my face.
Oh, yes, you
I do not.
I am not going to tolerate this from you, sir.
Yes, ma'am.
Fill out the request, get the form from our court clerk's office on the second floor, make sure it comports with what you've brought already, get it filed, mailed in, whatever you need to do. Let us assess her request. If it's,
My client's not seen her child. There is no order in this court, and there's been no jurisdiction found that this court has jurisdiction over this child.
Objection, Your Honor. Subject matter jurisdiction. Grounds. Sustained. Phyllis Druin. This guy isn't, well, gay or not. That's a female to male trans person. So it's not homosexuality that is at issue with the voice box. It is, well, you know, you get it.
Who has never lived in your county.
Verdict at 1:30 from Criminally Confident. That's 1:30 Massachusetts time, 12:30 our time. That's 1 hour from now. Man, I hope he goes not guilty. I really do. We will go back and check out some of that testimony that was brought up on close in just a second. Let's just, sorry, there's a couple minutes. I want to enjoy it.
Never lived. I did not. There was a pause. There was a break. I wasn't done with my argument.
and I
cares?
was not done with my statement. You interrupted again. Do not throw your...
I did not throw. It fell off the bench. Please stop stating things that are not true, ma'am.
Sir, you've got a room full of witnesses.
I'm not that thing's lawyer, but here's what you say. I apologize, Your Honor. That was not intentional. I didn't mean to throw or whatever. I set it on the bench. I just must have sat it down at a bad angle. Things are getting a little heated, and I wasn't paying attention to what I was doing. I apologize. Let me just take a minute. That's what you do. You got to calm yourself down. You're being a fucking weirdo right now. Being a weirdo.
I do. I put it down. I did. I put it down and it fell down.
We got to check your work. You know what? I believe him. I believe him. He didn't throw that thing. He just missed. He just missed.
Do not throw your...
I did not throw. It fell off the bench. Please stop stating things that are not true, ma'am.
Sir, you've got a room full of witnesses.
I do. I put it down. I did. I put it down and it fell down. I did not fall.
Then settle down.
I'm not upset and I'm not arguing.
You sound not
You're
upset,
not
not
letting me
arguing.
make an argument.
I'm not doing this. I'm not doing this. I'm not doing this. Stop saying I'm doing stuff. I'm not arguing. This is a shitty lawyer, but I like the tenacity. I'm on his side right now. I'm against the judge.
I'm not red in the face, ma'am. I'm not.
How would you know? How would you know if you're red in the face or not unless you're looking in a mirror?
don't get what we're both saying.
I am trying to make my argument. You interrupted my argument halfway through
This
on
is
an
a panic button
objection.
that will get every available deputy and
Yes, ma'am, I'm aware. It's happened to me before.
It has.
Yes.
Because you're out of line
Yeah,
with courts.
I guess so.
Okay. If I push that
Or maybe
button,
because I'm a transgender attorney practicing all over the state.
I don't know what you
You-
are.
I don't know what you are. Some kind of weird turtle person. Why is he all hunched in like this? This is the problem with identitarians, right? Like this is why like I shouldn't say everybody. Lots of people misunderstood the trans in the military thing and gays in the military. It's not about whether or not a gay person or a trans person can be an effective member of the military in any way except one that is the most important. So it was when the military breaks your identity down, you are depersoned and de-individualized for the purpose of being rebuilt into an effective, cohesive member of a military hierarchical structure that you must adhere to keep everyone around you alive. Nobody gives a shit on the battlefield if you're trans or not. But your trans identity might make you a liability if you're unable to break that identity away and just become a soldier, because you're no longer trans. You're no longer gay. You're no longer hetero if that's your identity. And if you have strong identity that you want to preserve, the Army isn't for you, and that's fine. But it's the identity that's the issue. The identity causes you to care more about this status or whatever it is than maybe something that could be critical in a moment, or maybe a piece of information or intelligence gets overlooked because of your identity, because you haven't been broken down and remade into a soldier. That's the problem. And once they figure that part out, there shouldn't be too much issue with it.
You, ma'am. It's not that you do.
I don't know whether
You do,
you're
ma'am.
Unknown Alien says, how does joining the military break down your sexuality? Not your sexuality, your identity. Hashtag not all homos and not all trans. It's just the people who make that status, their main identity. You've met them. I know you have. Everyone has. Unless you don't go outside ever. You have met people whose identity is so overwhelmed and encompassed by either their gender presentation or their sexual orientation. Well, most of us don't give a shit. I don't care if you suck dick or lick sniz. I don't give a shit. Why is this part of my day? But it's the overwhelming inability, and there's good reason for it. It's not like there's no evidence of why developing a strong identity has been important for these groups in fighting for representation and rights. Like that all makes sense. It's all logical, but just realize that the military isn't for everybody, and that's fine. That's it. The military just isn't for everybody. We want people who blow shit up, kill people, and save their squad mates. That's what we want.
You
gender,
do.
other
You
than
do.
you have just now
No,
advised me,
ma'am,
and
you
that
do.
doesn't have
You
anything
do.
to do
It's happened when we
anything.
talked on the phone.
That wasn't talking, let me tell you. You were entirely inappropriate.
You were yelling at
so-
me, and I did not even know you were the judge.
And I didn't know you from Adam.
I
at
said,
that
my name
point.
is Rob Hopkins. I'm
Which
an
doesn't
attorney
mean
in
anything.
Oklahoma City.
No, sir, you did not.
Okay.
Okay?
There's no one there to know that, right?
Okay, so we are pausing this until you get the ADA request form filled out and it gets processed.
So we're going to pause the hearing on jurisdiction that's been set twice. I drove an hour and a half to have the hearing. My client's available telephonically, and we are simply not even taking testimony.
Is your client available telephonically?
Yes, ma'am.
today?
Yes, ma'am.
Well, then get her on the phone.
Thank you.
Your Honor, to which we would object.
Oh, the counter, right? the other side of the scale. All of the testosterone that person is chasing is actually present in that guy's throat. Wait, hold on. I think that didn't come out right. I meant his vocal cords. His vocal cords were crafted by the fucking dwarves in Lord of the Rings. Good Lord.
This is as clear as the nose on my face that this woman will not appear before this court because she has a warrant for stealing.
Objection, you're saying that's not true. And you're ready
You will find, sir, that
don't come at me and it's over me or shout at me.
I'm not putting hands on. No, we're stopping.
Get out of my face, sir. Get out of my face, sir.
You may step
Get
out.
out of my face.
You should leave this county.
Get out of my face.
Did you hear that? Holy shit. You should leave this county. Oh, no.
This court because she has a warrant for stealing.
Objection, you're saying that's not true. And you're ready
You will find, sir, that
don't come at me and it's over me or shout at me.
I'm not putting hands on. No, we're stopping.
Get out of my face, sir. Get out of my face, sir.
You may step
Get out of my face.
You should leave this county.
Get out of my face. Get out of my face.
Squat up. The goons have arrived. Watch out. Look at this guy. What's happening back here? I don't even know.
Well, my friend, you're being ugly.
And get out of my face. Why?
Because you're in direct contempt of court.
He shouted at me. No, I'm not being. You did not even say that I was in
You are
contempt.
in direct.
No, I'm not
Judge,
doing
I
my stuff.
apologize, but I felt very threatened by this person. Not the screaming and the yelling in court. I've never even heard that before in this courtroom.
Attorney Sam Elliott over there. I think you should leave this county. Oh my God.
Do not hurt me. Do not hurt me.
Don't hurt me!
Do not. Are you throwing me over this?
Stop resisting.
I'm not resisting.
Okay.
You literally are resisting.
You know exactly what's
Why
happening.
don't you all walk that way sometimes?
I love that the cop, he says, I'm not resisting. And the cop just goes, and clearly cannot easily push them forward. You're resisting. Yes, you are.
I can't walk. I'm being thrown down.
I'm being thrown down.
Settle down. Do not grab me. Do not grab me.
Ah!
What are you doing? What are you doing? You're hurting me. You're hurting me. You can't take me. You don't get it. I can't.
This is like a person going off an unfinished overpass. It's like you had every exit, buddy. Every single exit leading up to this. And you chose not to take any of them. What's wrong with you? Don't hurt me. Ah!
Breathe. I can't breathe. I can't breathe. I can't breathe.
You're breathing just
I
fine.
cannot breathe. I can't breathe. I can't breathe. I can't breathe. I can't breathe.
Sounds like the Jeff Goldblum's dad, or no, not Jeff Goldblum's dad. Sounds like the owner or like the boss of the newsroom in Independence Day. Do you guys remember that? Oh my God. Whoever that actor is, that's who this sounds like to me. No! The chairs are poor victims!
Somebody call 911.
Don't worry, the cops are already there, pal. What are they going to do? They should get out of phone. 911. Don't worry. Erica, we got it.
Please.
I'm sorry. Is he a producer for an EDM like artists. Like, Charlie Puth can make a song out of that. Okay. I'm seeing promise. Guys, I think we need to put the pleases and the ows into Suno. I think we need to do that. I need to get those isolated. We need to put those into Suno. We got to make a dance track, baby. Oh, we're going to fucking ruin this. Not right now. Calm down. Eat some Cheerios.
Somebody call 911. Somebody call.
I got your phone now. All right, we're gonna pick you up. Go on inside.
No, I don't. Get a female officer now. Get a female officer now.
I wish one of them would say, son, this is Oklahoma. We don't do that around here.
Get a female officer now.
There aren't any.
I can't get up. I can't see. He just threw my glasses. I can't see. Give me my glasses. Put them on my face. No. Put them on my face. I cannot see.
Put them on my face.
Go.
Please give me my glasses. I cannot see. I'm not trying to walk and I cannot see.
I'm not trying to walk.
Thanks, Robert.
Don't you mean your purse? I don't actually, I don't give a shit about trans people, like, negatively. You know what? Like, they're just people to me. I don't care. But it is funny when ones like this show up.
Thanks, guys.
You know, I just thought about that. So, I saw you guys laughing, which was very rude, about reverting to factory settings and stuff. And I laughed when asked for a female officer. But let's take a step back. Let's take a step back and go, wait a minute. That person's a man now demanding a female officer. Right? Like, you're a man now. I don't think the men in the chat could reasonably ask for a female officer without sounding like a fucking creep. There it is. Miss Sparkle says, loving the suit. You're in your glow up phase. Thank you. They had a couple other suits from this company, or jackets from this company, but they weren't. The one was blue, and I have a lot of blue jackets. It didn't really pop. And the other one was kind of gold, which I have to be really careful with those. But we'll see. We'll see. Well, that was refreshing. I like that. That made me happy. Okay. So we need to go back to day 2. So give me a second. We need to go back to day 2. 2 hours, 32 minutes. I don't want to watch the court TV one. Oh, well, I get that one's probably fine. Two hours, 32 minutes. Okay, so this is allegedly testimony about the, testimony about the bullet in the chamber, because I missed the bullet in the chamber testimony. Court is not back. We're right here. I've got it pulled up, full volume. We'll know.
All right, and then the last item is that he was put on administrative leave and allowed to work.
This is not 2 hours and 32 minutes. That's not correct. It was a 2 minutes. Okay, so whoever sent this super chat, calling you out. Aaron Burr says, Nick, day 2, 2 hours and 32 minutes. Mark is testimony about emptying the gun. Oh, was that 2 hours and 32 minutes on my stream? So here's him. He's still testifying here. Oh, damn it. Who, it was this guy. It was this guy. Okay, so this is from day 2. It's this fake Shane Gillis, I think. Ash Elizabeth gifted a membership. Thank you, Ash. How you doing? Nice to see you. Always a pleasure. Is today Wednesday or Thursday? Today's Thursday. Shit. Camelot and I are supposed to do a show every Wednesday, and I've been really bad about it. I don't think Wednesday's a great day for me, so I got to talk to him about figuring that out, because Wednesday is proving to be difficult. Okay, so here we go.
Yes, please.
Sir, in a loud, clear voice, can you please introduce yourself and spell your first name and your last name?
Good morning. My name is Officer Stephen Corr. Stephen,
is this the guy, Stephen Corr?
Steven. Last name is Corr, Corr.
I don't trust any of these guys as
I'm a police officer with the town of North Andover.
And how long have you been doing that?
About 15 years.
Okay, what are your duties and responsibilities now?
I'm on patrol 4 to 12 shift.
He also looks like he just came in from splashing his face in the bathroom.
We respond to everything.
Is the wrong guy? Okay. Who is the guy? Was it this guy? This is the forensic guy. But he's not the guy who is at the scene, so it wouldn't have been him. Wait, it is this guy? He wasn't at the scene. Right? Oh, God. I'm so confused. So confused.
So all these components combined will make one combustible material. You'll have what's called a firing pin. It'll strike the primer.
You talked about it.
Ignite the powder inside of the casing, which holds everything together. Once the gases build up from the burning of the powder, the projectile will leave that casing.
So the projectile is what's commonly known as a bullet?
Yes.
And the casing is what...
Okay, so he collected the guns. I thought he just examined them later on. I didn't realize this guy was at the scene. My bad.
is often recovered at crime scenes?
It's also referred to as a discharge cartridge casing, so it's been extracted from that firearm.
I'm working on some tools, by the way. I shouldn't be talking about this. The government will get me. No, I'm working on some tools that for upcoming trials where we'll be creating like a searchable transcript and actually be able to in real time check and see if there was something. If something doesn't sound right, we could say it'll be it won't be perfect at first. We'll have to train it, I guess. But I'm going to set up an AI that can look for shit like that, that can go back to transcripts from prior days' testimonies that are generated on the show, and it'll be able to grab the answers from that person. We could say, hey, what did so-and-so say about this? And kind of see how that goes. And it might actually, I think I can maybe get it to automatically spot potential contradictions. So we're building stuff
Is there a way
behind
for
the
you
scenes.
to determine whether a round has been discharged from a working firearm?
There is. So you're looking at the tool marks of what's left over on that discharge casing or that projectile. So originally,
Show
you
you
look
my
at
discharge
is
casing.
in regards to a projectile, twist to the left characteristics, make sure as far as the tools of wear and there isn't one firearm that is the same due to the fact that you'll have material that's in front of these cutting edges.
And is it fair to say that when a cartridge is new or from the box, it does not have these particular
I'll
two
email
marks
you.
you're looking for?
It shouldn't have any of the two marks. It may have some type of markings, what's called bunting marks on a discharge casing.
I'll give
This
you
is
some
from
bunting
stamping
marks.
that, it's bunter.
Shut up,
The
you
caliber
bald
as
piece
well
of
as the
shit.
manufacturer.
Comes apart from a projectile. Does it come out where a particular word?
And the general is manipulating the length of that. The trigger pull per
I'll manipulate the length
primer.
of your trigger
Explosion's
pull.
going to extract that discharge magazine well and load the next live cartridge.
Okay, hold on.
Slide's it's gonna hit. It will cause either a hammer or a firing pin to move forward. Will strike the primer. After it strikes the primer, it will cause an explosion. Explosion is going to cause that slide to go backwards. The extractor is going to extract that casing, which is attached to that slide. And it's going to hit what's called an ejector. The ejector is going to extract that discharge casing out of the ejection port, and it's going to continue the cycle. The slide is going to move forward now because it's under spring tension. It's going to pick up that other live cartridge that's in the magazine well and load the next live cartridge.
But does the user have to do something first before they are able to pull the trigger and have a projectile fire?
So they would have to load either manually or with a magazine. So a live cartridge has to be inserted into the chamber.
And does the slide, or does the slide have to be pulled back?
The slide has to be racked to the rear, yes.
Okay. And so the slide has to be racked to the rear just one time before the shots are fired?
Yeah, so you have to essentially cock the firearm. So you have to put some external force on that firing pin or that striker to hold it in place. When you pull the trigger, you're going to have that transfer bar or that trigger bar, whatever you want to call it, will actually drop. We'll engage that trigger bar or that striker to move forward and move past the aperture, which is the circular portion, and right in front of the primer that sits in front of the chamber. So all these things have to happen, but initially you have to have a cocked firearm for it to happen. So you have to load that live cartridge and put some external force on that slide to cock it.
And is cartridge synonymous with magazine?
Cartridge versus magazine, so a cartridge would seat in a magazine.
So the cartridge holds the projectiles or casings in the magazine?
Yes.
Okay. And what part of the gun is the magazine?
So it's an external piece that's inserted into a magazine well.
So a user would take the magazine, enter a cartridge which contains the bullets, and then seat it in the handle of a semi-automatic weapon?
So the person would load the ammunition inside of the magazine. The magazine will have a spring tension as well as a follower on top. That spring tension pushes that live cartridge to the top of that magazine at all times. That live cartridge is stripped by the slide or manipulated by putting that live cartridge in the chamber manually, but ultimately you do have to cock that weapon to fire it.
I'd like to direct your attention to June 30th of last year. On that date, in the evening hours, did you get called to go somewhere?
I did.
Where did you get called to go?
To a residence in North Andover.
What information did you have when you arrived?
Information I had was there was a police-involved shooting which required a supervisor to attend the scene.
And that's why you went?
Yes.
Okay. What time did you arrive?
I don't recall exactly what time. It was in the evening hours.
Did anyone else from your unit respond?
Yes, I had a trooper, Chris Pierce, as well as trooper Andrew Valeri.
And the three of you responded from the firearms identification unit?
Yes.
And what was your purpose on scene?
We wanted to document the scene. We wanted to inventory all personnel that were involved in the shooting, whether they fired or not, to inventory their weapons. to account for all live cartridges.
And again, is that standard procedure for an officer-involved shooting?
Yes.
When you responded, who was on scene?
There was several detectives from the Essex County Detective Unit as well as Andover police personnel.
North Andover police personnel?
North Andover, yes, Mike, sorry.
South Andover.
Were you directed to a particular part of the house?
I was. There was a particular part in the top of the stairs where there was a firearm located in a safe, as well as a bedroom where we recovered a 2 discharge casing as well as a projectile.
And did you or someone from your unit or someone from the state police take photographs that evening?
Yes, we had crime scene services photograph the scene.
I know the chat's not
and what is crime scene
moving.
services?
On,
So they're a unit in
screen,
Massachusetts State Police. They
StreamYard's
document,
having weird.
they photograph the scene, they
weird shit
videotape the
today.
scene to preserve the scene, as well as do prints on firearms casings and so on, as well as footwear impression markings.
May I approach?
Yes.
Sir, I'm showing you 9 photographs. I just ask that you take a look at those and let me know when you're done.
While you're doing that, Counsel, Mr. Breda, will the defense be objecting to any of these?
I don't know what counsel has up there.
Okay. Breda and
I want him to testify about the gun. I think this is where it is because it looked like the pictures of the bullet.
Okay, let's have Mr. Wayne mark those individually.
Sir, I'm showing you.
Okay, this might be it.
Sir, I'm showing you first what's been marked as being
30 minutes till the verdict is
Recognize
read.
that picture?
Yeah, the picture dictates plaque number 3. I believe
What's
there
on
was
your
a
mind?
discharge casing around that vicinity of plaque number 3.
Sir, what number was that again?
81.
81, thank you.
Is Exhibit 82 a different angle of that same, you were trying to photograph that same discharge cartridge casing?
It is.
Showing you Exhibit 83. What does picture 83 show?
Discharge cartridge casing with the closer-up appearance.
Has it been moved?
I believe it has been moved.
And why would it been moved?
Where it was located, it was kind of in a confined space in the corner of the room.
Okay.
Showing you Exhibit 84. Do you recognize Exhibit 84?
Yes, it's where a smart.
We didn't really focus on that too much, but the bullet casing from Noonan was admittedly moved. It was admittedly moved from where it landed. Oh, because it was in the corner. But we don't have evidence of that. That goes to the question of where Noonan was standing. Why is it moved? Like, I'm guessing it was like wedged down between like the, like the carpet, where the carpet meets the wall. It's like stuck down in a thing. So they couldn't get their cool little measurement, device. Well, it's not really a ruler, is it?
Projectile was recovered right above the air conditioning unit inside the curtains.
Exhibit 86.
I'm sorry, can you just give me one moment to just catch up?
Do you need the picture?
Do you mind putting that back on? Okay, thank you.
What does picture 80, exhibit 86 show?
It's a close-up picture of placard number 4 of that spent projectile that was recovered in the curtains.
And showing you exhibit 87. What does exhibit 87 show?
The projectile from placard number 4 that was moved for a close-up photograph.
So it's taken from the air conditioning unit and moved for this photograph?
Taken from the curtain and moved on, I believe, the bed, and taken a photo of it.
Showing you exhibit 89. What does exhibit 89 show?
It's where a projectile possibly struck. We looked at the air conditioner inside and to the rear of it. They had a hole consistent with a strike on the outside of that air conditioner. Can't determine exactly, but it appeared to be a projectile strike, and there was another hole on the exterior or the back end of that air conditioner as well.
And is that what exhibit 88 shows?
Yes.
And did you ever find a projectile associated with this air conditioner, the one that struck the air conditioner?
I did not.
That last photo, that one there, is that 85? I'm sorry, 88? Thank you.
A great crowd over on Rumble today. Never wanted to sound like I'm not paying attention to you guys. I always am. Always watching.
It appears to be another discharge cartridge casing by placard number 1.
And is exhibit 77 a close-up of that discharge cartridge casing?
It is.
And what did you do with the discharge cartridge casings and the spent projectile that you recovered from the scene that night?
So all pieces of evidence were documented, where they were located by placard number, the time of location, who recovered that evidence, and any particular features of that discharge casings, the head stamps or bunter marks.
So you collected the evidence and documented it, fair to say? And is it, in summary, fair to say that you recovered 2 discharge cartridge casing and 1 spent projectile?
Correct.
Sorry, I was distracted. Can you ask that question again?
Sure. In summary, is it fair to say that you recovered 2 discharged cartridge casings and 1 spent projectile that night?
That's correct.
Okay.
Thank you.
Did you continue your search of that bedroom?
I did.
And what else did you recover from that bedroom?
I don't believe there was anything else from the bedroom other than the 2 discharge
I'll be
casings.
right
and the
back, guys.
projectile.
This is right where it is.
May I approach, Your Honor?
Yes. Oh. Let's, we'll take a 5-minute recess.
All rise. We're still in the 5-minute recess. Please don't exit the floor.
Okay. Wait. So they have a little break.
Firearm that was recovered at the top of the...
Here we go.
2025 of a number of firearms the night of June 30th, 2025.
I did.
And whose firearms did you collect?
There's 2 North Andover police officers' firearms and another firearm that was recovered at the top of the stairs at the residence.
And the 2 North Andover police officers, was that Tim Houston and Patrick Noonan?
Yes.
And did you also inspect?
Just as a note, guys, I have an appointment at 2. I completely forgot that I have that. I have an appointment at 2. 12:30 is my time. 12:30 is the jury or the verdict reading. So we will still get to that, I believe, unless he takes a really long time. But I will have to go pretty quickly afterwards. So I was just reminded of my appointment.
Lieutenant Daly's firearm on scene.
I did.
And what did you determine with respect to Lieutenant Daly's firearm?
He had...
Well, I'm sorry. This almost only happens in Lawrence. But the window's open over here, and which is what we need for because of our HVAC. But I'm having so repeat that.
Firearm.
4 rounds. He had 1 magazine, so he was fully loaded. There wasn't any unaccounted for rounds of ammunition.
Okay.
Wait, I'm confused because I thought,
Tell your dentist we also
thought
have.
you took.
No, I had
Officer
the dentist.
Houston and Officer Noonan is what I wrote down, but is that?
Fair to say you took Officer Houston's firearm and Officer Noonan's firearm.
Correct.
And did you take Lieutenant Daly's firearm?
I did not.
Did you just examine the number of bullets in his magazine?
Yes, I...
Well, she's leading because the judge was distracted by the outside noise. So, and I'll allow you to do so as well, Mr. Gray. So overruled. All right. So now I understand. Thank you.
And sir, I'm next going to ask you if you recognize what's shown in Exhibit 10.
Yes, that is the firearm at the top.
So again, it's always nice to have some confirmation about this is right, what we are looking for. But trolling through Twitter, not like trolling on Twitter. Runkle says, watching the Commonwealth's closing and wondering about if there's no expectation of confronting a witness with the Commonwealth's theory of events. Here in Canada, this closing would be getting scorched by the judge in reasons. Judge in reasons. I don't know what reasons. I just like the confirmation that we're not crazy, right? That closing felt wrong. It felt scummy a little bit.
Top of the stairs, as well as a magazine with numerous live cartridges in it, as well as 1 loose live cartridge.
Is this the loose live cartridge here?
It is.
And so loose live cartridge is in the box.
I'd like to ask you about your major findings in this case. Based on your training and experience, did you conduct microscopic analysis with respect to the projectile and...
Wait a minute. The loose cartridge is in the box. That's all he said. Right? He didn't testify about how that loose cartridge got in the box. Someone said that he took it out. Am I crazy? Am I missing? I am fucking missing something, I think.
Cartridge casings that were recovered from the bedroom of Phillipsbrook Road.
I did. So I testified all 3 weapons. And
I hope not.
conducted a microscopic examination of the class characters as well as the individual markings that were left behind from the firing process. I was able to conclude that the weapon that was fired by Officer Noonan created the discharge casings that were recovered in the bedroom, as well as the spent projectile that was recovered above the air conditioner.
And were you able to exclude any weapons?
I was able to exclude the other firearms.
I'd like to change gears a little and talk about the weapon that was recovered from the black safe at the top of the stairs. Did you do anything with respect to that gun?
I test fired that weapon with 2 live cartridges from submitted ammunition.
And what was your conclusion?
That weapon did not fire the discharge casings as well as the projectile that was recovered.
So the gun from the black safe was also excluded from the discharge casings and the projectile that were recovered from the bedroom?
Correct.
But did the gun operate?
It did operate, yes.
Was there any problems with its operation?
There was no malfunctions.
Did you bring with you today a box?
I did.
And what is contained within that box?
I believe it was the that Glock.
The guy that sent you the timestamp was correct. Damn it, you people! I blame all of you. Okay, so this guy wasn't the testimony we're looking for. Two hours, 32 minutes.
Date, you overslept and you only received a public a written substance. All right, and then if this were to accept whatever the testimony is under oath to that answer to that question, I'll just remind you, because I'm reminding you, I'm really saying this for our audience, not you personally.
And how long have you been doing that?
About 15 years.
Okay,
15
what are your
years.
duties and responsibilities now?
I'm on patrol 4 to 12 shift. We respond to everything, 911 calls, domestics, motor vehicle accidents.
Kelsey Fitzsimmons?
Yes.
Okay, did you know where she lived?
He did.
What was that?
He pointed right where his hand had been, and he said, secure that firearm.
Okay.
And I had looked down, there was a firearm sitting on I want to say a white-looking bookshelf.
Okay. Was that near the door?
Correct.
Why is the firearm on the bookshelf? Oh, because Noonan picked it up and moved it, right? Is that how that worked?
Can't find that picture right now. I'm going to show you what's been previously marked as exhibit number 57. Do you recognize that?
I do, yes.
And what is that?
That was where the firearm was located, on top of that white-looking bookshelf. I guess it's not a bookshelf, but...
So this is the room you rented, correct?
Correct.
And this is the door you went in?
Correct.
And is this the area where the gun was?
That's where the gun I saw was, yes.
Okay. And so...
Yeah, we've got 14 minutes until the verdict. 14 minutes. The verdict watch is here, waiting for the court to come back. We'll know because we'll hear it. And, but in the meanwhile, reviewing testimony, checking the state's closing argument. Because I don't remember this guy, anyone testifying that they cleared the round from the gun.
You didn't know anything about the gun at the time, whether it was loaded or not, right?
No, I did not.
Okay, so what did you do?
I had gloves on at the time. I picked up the firearm. There was a small black box on the bed. I saw that was an open box where I could store the firearm because I knew paramedics and fire department.
Okay, they changed it to 1 p.m. our time. 1 p.m. our time. Sorry, our time being Central Time. So 30 minutes later, of course. Make it more difficult for me. Damn it. Hold on, I missed his statements. But yeah, so 30 minutes later.
There was a small black box on the bed. I saw that was an open box where I could store the firearm because I knew paramedics and fire department was going to be coming in that room. It's not a huge room, so I wanted to get it out of the way so it wouldn't be trampled, wouldn't be disrupted or anything. I took the firearm, I looked at the box, there was nothing in it. I kind of did one of these motions to make sure there was nothing in it. put it down. I dropped the magazine out of it.
And what does that mean, dropping the magazine?
I hit this release button on the side of the firearm. It takes out all the bullets that are in the magazine.
Okay. Bullets stay in the magazine.
The bullets are in the magazine, correct. And then after that, I racked the slide, had it sideways, and I emptied a round out of the chamber.
There it is. Okay. So he says he racks a slide and empties it out of the chamber. Problem, of course, Officer Noonan moved the gun. Easily had time to chamber around. Or again, this guy could have chambered the round himself and then cleared the round out of it, or just pulled the round straight out of the magazine. Any of those things could have happened. It's hard to say, right? But even so, Kelsey Fitzsimmons racking the round doesn't actually surprise me at all. If she's trying to shoot herself and she gets nothing, her racking the round makes sense because she's trying to shoot herself. She needs the gun in the chamber. But that was just a point of confusion for me. So he testified about it here. Let's see. Man, StreamYard's really pissing me off by not showing what's going on. But Chichunia has gifted 5 memberships. Thank you, Chichunia. Nice to see you. And also, I think there was a super chat. Yes, there was. It didn't have anything in it, but it was appreciated. I mean, it had a value to it. It just didn't have any words. So thank you, Chichunia, for the 5 memberships. That's awesome. Very much appreciated. That brings us to 27 members for the show today. You guys are always wonderful and generous. And there's some, this trial's about to be over, which means that, the whole 8 hours a day thing is going to go by the wayside. And we'll have some time to do some regular streams and member streams and streams about some other stuff. And then I'll be looking for another trial. I especially like these short trials. I don't really care if the trials themselves are super hype or popular, big media events. If they're interesting.
Box.
Okay, so there were a magazine with a number of bullets in it.
Correct.
The one round or bullet was racked into the chamber itself, correct?
Correct.
And then that go in the box?
That went inside the box.
And what did you do with the firearm itself?
The firearm, I put everything in the box.
Okay.
Kelly, no, there's
brought it outside of the room.
No body cams at all. Body cams would have answered this case in a moment. Well, Noonan wearing a body cam would have answered this case in a moment. It would have solved every question, wouldn't be a case. Assuming she's, not guilty, it wouldn't be a case. If she was guilty, it'd be pretty quick.
And ask if you recognize what that is.
Hold on a second. So this is image
not agreed to, so it's a picture that.
Okay. All right. My question was, and you just answered it by your movement, was whether you wanted me to look at what was on the screen.
No.
All right.
I don't think we need any more. I didn't hear that testimony before. Bothered me that he said it, and I didn't hear it. That's covered now. We know that was stated. Whether or not you believe him, whether or not there's a competing narrative about it, those are different questions. I just didn't hear it at all. I didn't hear it on the initial playthrough. Is there any other video that you guys would like to watch from this case? Nick, you got to move your dentist. It's not a dentist appointment. I can't move it. And if it's at 2, I should still be fine. 2 Eastern. I'm in Central Time. So that's 1 Central. I should have plenty of time to do the do the verdict and then buzz out for my appointment. Miss Sparkles says you got to do the David trial when it starts. What's the David trial? I think you sent me something about it. I just don't remember. Was there cross on the chambered round? We could check. There wasn't much.
So you've handed him a photo.
Small,
He admitted.
And in the position where
doing rendering downstairs, the firearm, and
on the
walked in. I said, "What that?"
after
Me this whole.
Okay, so the state sits down here.
Yes.
Officer Core,
Bradle.
Officer Core, good afternoon, sir.
Good afternoon.
Now, I'm sure that you memorialized all of these important facts you testified to in a police report somewhere.
No, we didn't generate a police report at that time. No,
Well, I'm not asking if we did, I'm asking if you did.
I did not know, sir.
Excuse me one moment. Do you mind going to the
Oh, sorry.
podium only because to make sure that the audio gets picked up.
Everything you testified to was not memorialized by you in a police report, correct?
No, I did not write a police report. No.
Now, also, you weren't interviewed until 30 days after this incident, correct?
Interviewed by who?
By the state police.
I don't remember the exact time frame.
Isn't it true that you were interviewed on July 30th?
I don't know the exact date. If that's what you say it is, then I assume you're giving me correct information.
I appreciate that.
That assumption.
You were also working with Officer Noonan, correct? At the time-
I work
in that
with him
time
as a
interval?
coworker.
Did you work with him in that time interval?
From when the incident
to the
happened to
30th?
July 30th?
July.
He's on a different shift, but yeah, I do work with him.
And did you speak with him about the case?
I don't recall if we did. I'm sure we had talked at some point about if he was okay.
Did you speak to him about what happened at the scene? Just yes or no?
At the scene we did, absolutely. We were on the same scene.
Okay. And did you speak with him in the days following?
I couldn't tell you. I'm sure we at some point talked.
And what about prior to your state police interview?
I'm sure we talked at some point.
So you spoke with him at the
Are you
scene?
sure that
spoke
happened?
with him probably shortly after, and spoke with him prior to the interview as the interview approached. Is that fair to say?
Yes.
Thank you very much. Nothing further.
Any redirect? No. Okay. All right. Thank you, officer. You may step down.
You're welcome. Thank you.
Come with you. Call your next witness.
Thank you, Your Honor. Michael Bonasaro, please.
I got distracted. Shit. Was there cross on the bullet? Cellulite Podcast says, could you explain deferred prosecution agreement? Yes. Sorry, I'm not super familiar with the term because they don't use that in Minnesota. In Minnesota, they call it a continuance for dismissal. Basically, it's an agreement between the prosecutor and the defendant, and the prosecutor agrees to withdraw the prosecution itself, although hold on to it typically, and requires some sort of things from the defendant in exchange. They make it's sort of like a plea agreement, but it involves non-prosecution. They agree to defer prosecution if you complete these other conditions. So Minnesota has something similar called continuance for dismissal. Good luck getting them. Really hard to do. But when you do get them, they're great because your client is uncharged. They withdraw it. It's not even dismissed out. The charges are pulled. And the state says, we'll keep an eye on it. As long as your client doesn't screw up in the next year, we'll just forget the file exists. Some states probably have a more formalized process than that. Yeah, so no cross on the bullet. The cross on the bullet actually did occur, but in a very indirect way. The cross on the bullet was simple. It was, surely you wrote this down. Surely you have contemporaneous reports about what you did involving a critical piece of evidence, the gun that was allegedly pointed at Noonan. Like, surely you made a report about it at the time. He said, no, I didn't do that. Oh, okay. So we have nothing to corroborate it from when it happened, just your word way later. And that's how these Massachusetts things seems to go, isn't it? All right, I'm going to end the poll. If you haven't participated in the poll, now is your chance to do so. We have 1,400 votes so far, which is pretty good, considering we have less than that in people who are present. That's a pretty good result. That means some people have cycled in and out, which is cool. If you are cycling in and out, or if you're staying, guys, we're 41 now. 41 likes away from 500. But I think there's enough of you to get to 1,000 likes. I really do. And I need people to like me. I need it desperately. So if you guys could go ahead and click the like button, I would always do appreciate it very much. It's a very inexpensive way. It's basically completely free. It only costs your dignity to support the show. And it is meaningful and helpful. So I always do appreciate that. Thank you. But only do it if you actually like the show. If you don't like the show, please don't. You can. I'm not going to stop you. Locals just doxed me? Shit, where? How? That's true. And they did. What's up with the glasses? Haven't been here in a while. I like them. That's it. That's the whole explanation in the glasses is I like making glasses part of the various outfits that I'm wearing. Actually kind of mad because my blue glasses broke. So now I am these are a greenish blue, which is nice, but not fully there. But that's the problem with gas station glasses. Those are gas station glasses. Those are my blue ones. Very sad. Tammy Fayette says, you look lovely as always. Thank you. Thank you. Lori Woodward says, love your glasses, Nick. Thank you. I do really like these quite a bit. Oh, thank you. Calebly, welcome. Welcome. Just subscribe because of what you've been through and overcoming the odds. I don't like to do this. Someone comes in and says something nice. I want to offer a mild correction. Not a correction. A mild adjustment to that statement. What my decisions put me through. It didn't happen to me. I made the choice. I chose to do the things that led to what happened. That was me. Not all of them. There are things that I didn't get convicted for. There are reasons for that. However, the drug possession.
To take his big brother Cal away from their parents.
It's devastating. It preys on all of your worst anxieties as a parent.
Sarah Perkins and husband Josh shared their ordeal with.
Okay. They started covering something else. I don't know what that is. I don't really want to know. But yeah, I mean, I made the drug use and stuff. That was a time in my life. I was doing that. It was my fault. I did have it. I made those choices. So, but I really do appreciate what you said. I don't think you meant anything different, but I always want to be clear that it it's my responsibility and my accountability on it. I laugh and joke a lot, and I talk a lot about the time that I spent doing insane things because they're insane. Like it was wild and fun and crazy. It couldn't go on, you know, but it was those things. That's why people do it. And those experiences happen. So I share them because not everybody can share their experiences. And I just hope that it helps people make informed decisions about their own life and safety. That's it, you know. Everything we go through in life is fodder for wisdom somewhere. I'm not saying that you have it because you went through something, but someone else might gain or glean wisdom from what you went through, and stuff did happen. Talking about it doesn't mean that it's happening again or now or anything like that. And some people necessarily need to not talk about it. Could impact their jobs and stuff like that. Well, my shit's all out in public. It got thrown right out there. So there's no use like not taking advantage of it and sharing those stories when it's appropriate. But please don't make the mistake of thinking that means that that I'm not responsible for what I did. I absolutely am. Wish I could talk to JD Delay about your experiences and how you are now on the other end of things. Who the hell's that? Judge has reached a verdict. Live coverage soon, of course. Yes. We're waiting. It looks like 26 minutes till verdict is going to be read. Hopefully the judge will pull everybody into the courtroom, a little bit sooner. It'll get started right around that time. The Boston area police are taking a hit on credibility over the past 2 years, aren't they? 3 years, I guess. The wood chipper guy. Okay, JD Delay. Who's that? I'll look him up. Who DF is JD Delay? Inside a meth addict's brutal lifestyle. He's a former prison gang leader and career criminal. Opens up about his turbulent past. So he's a former meth addict. He wants to wood chipper all pedos. Oh, well, we have so much to talk about immediately. Immediately, we do. Okay, prison life, addiction, recovery, often interviewing others with similar backgrounds. I'm not hesitant to talk to him. I could probably have a great conversation with him, would love to. I'm always kind of hesitant to, how do I word this? Represent myself as like that sort of typical story. One of the things about recovery was you get to sit in a room with a bunch of other people, and man, their stories are way different than mine. Way different. There's a couple different cultures around drugs. Like there's the party culture, which is more of what I was into. And then there's, there's the lifestyle, or not like lifestyle, the plague culture of drug use, which is what some people are born into, parents that are addicted to drugs, or they're in environments where drugs are prevalent, and they get into them at a very early age, and they impact and sculpt everything that's around their life. I wasn't like that at all. My drug use is very baffling to some people, and that's okay. Not everything is for public consumption, but I didn't have that story. I don't have like, I went through trauma, so I turned to drugs. It was like, no, I had an opportunity. I had some personal reasons, and those personal reasons will remain personal. But I had an opportunity to do it. It turns out I enjoyed it. I enjoyed the culture and, again, that partying lifestyle. It wasn't the trailer park like drug dealer or drug purchaser lifestyle. And I knew a lot of those kids growing up. I grew up I went to high school in a relatively wealthy suburb of Minneapolis. However, it did have a very large trailer park, and I'm not saying that as a joke. It had a very large trailer park, and that was like, it was like two different worlds in between those. The upper middle class to upper middle class, main like suburb, and then this one section, and it's like a lot of the kids from there went to jail, or juvenile detention or whatever, got involved in drugs during high school and stuff. I was friends with some of them, but I was never into drugs at that time. So anyway, but I'd talk to this guy. I just don't want it to sound like I'm a hardened prisoner or anything. I went to jail for 26 hours. Very fortunate in that. Trying to stay out of, going back to any sort of prison. That would be nice. Am I a cake eater? I'm not from Edina. No, Edina was still considered wealthier than Lakeville. But I grew up in Lakeville. Lakeville has changed quite a bit since we moved there. We moved there in 1991. There were only 3 stoplights in the whole town. It was very different. Now it's a much bigger suburb and has very highly competitive high school sports programs at both of its high schools. And so depending on if you have a son or a daughter and what sport you play, people strategize to get into different houses around there. It's it wasn't quite that bad when I was there. Joji, though, is correct. Cake eater? No. Snizzlicker? Yes, absolutely. No, your drug use is very sophisticated. It wasn't sophisticated at all. I wasn't raised by parents who were drug addicts or drug users. I wasn't enmeshed in the culture. My parents didn't beat me. At recovery, everybody there had a story of their dad breaking their ribs, getting in fights with them. Way different life. That's all I was saying. What's sophisticated drug use? What would that look like? I don't know what that is. It was a party and it was fun, man. That's that. Well, I mean, that's what the drugs chemically convince you that everything is good. Again, why people do it. This is a long chemical story. Doesn't really matter. 12:40. Come on. This news station here is driving me nuts. I don't care about your other stories. What a waste. Maybe I will pull that away for now so that I can keep watching. I don't want to steal their stupid content. I'm just waiting for the court to come back. And so I've got it pulled up, but there's no reason to have it on the stream. It's also a very classy and upscale edition. Yes. So you're a poser. Wait, what? No, I don't I don't think so. Oh my gosh. Guys, the Celtics beat the Thunder 119-109. Oh my goodness. So do you guys have any eyes on any trials that are coming out in the next couple weeks? I don't even know. Here, let's see. See if I can find this answer. What broadcast? What public trials? Are starting next. See if the AI can find something. Courtney Clenny starts at the end of April, like April 23rd or something like that. What happened to the trial where the cop shot the judge in Kentucky? That was reported to be about to start, but that report was incorrect. They're still in some pretrial motions. I don't know what time that will be. There's also the sheriff who won his election after murdering the pedophile. His trial is coming up. Arizona versus Lori Vallow is March 31st for jury selection. I don't know anything about the Lori Vallow trial. I know other people have been following it a lot. The Chad Daybell, Lori Vallow. I don't know. Let's see. This Arizona case involves the murder of her fourth husband and attempted murder of her niece's ex-husband. So there's Lori Vallow. Brooks says, good afternoon, Nick. Your lovely jacket reminds me of Captain Kangaroo. I think his was green, though. Hey, Beth Roberts. Glad to be of assistance. Sorry I had to take a break there. Let's see. Nevada versus Dwayne Keffy D. Davis. Tupac Shakur killing. Hey, just 1 second, guys. There's a sales call. That's not exciting. Let's see. 12:45. We're coming up. Okay, so we've got the Tupac Shakur killing. First criminal trial tied to the 1996 killing of Tupac Shakur. Nearly 30 years later, this already started. March 17th. So that one's still going. That one's interesting. Wait a minute. Massachusetts versus Karen Reed retrial. Starting April 26th? That doesn't sound right. That sounds like the AI screwed that up. Larry Malit, California Maya Malit trial that started March 9th. I don't think the AI understands what upcoming public trials is. How about a review of the quadriplegic and being a murder suspect? Well, yeah, but that trial's not going to be for a while if it even has one. Sarah Grace Patrick. It's defendant charged as an adult for killing her mother and stepfather. Allegedly started January 5th, but civil trial for Karen Reed. Okay, that makes sense. That makes sense. The wrongful death trial, right? Man, I don't think I want to cover that. I don't think I want to cover the Karen Reed thing. I don't know. So many people are going to be covering it. So many people are way more like into it and enmeshed in it than I am. Verdict is coming in 12 minutes. So we're just waiting for the judge. I have the, oops. I have the window open, just waiting to see the courtroom show up. Oh, hey, speaking of showing up.
Thanks, Nick. You got me to upgrade my clothing. Just bought a $1,500 suit. I got it for $800, but still. And it will be fitted because men should be able to dress like men, but I still love my cargo shorts for vacation. But dressing well and carrying yourself appropriately leads to more respect.
Absolutely. Look, you can like your cargo shorts for vacation. I'm not actually here to tell you how you must be at all times. I'm just mostly frustrated with the idea that society's been telling men over and over and over that they don't have to do anything aesthetically other than maybe lift. But they don't want men to get into a certain kind of shape. It's like, oh, you just have to lift or whatever. And we're told over and over that every aesthetic that seems to result in us being like lazy, sitting around and not getting what we want, that's the desirable one. Yet you can't ever find someone in real life who desires it. Just bothers me. Just bothers me. Already occurred. I don't want the Supreme Court. Well, that answer was garbage. I'm going to ask a different one. Can you tell me how I must be? I'm tired of making decisions. I mean, I can, yeah, but I'm not going to do that to everybody. Let's see. Let me see. What publicly broadcast trials are starting soon? I know the sheriff one is going to start pretty soon. And ideally, so like the Afro Man trial and this trial kind of came at me really quickly. I didn't have a ton of time to pre-game them. Ideally, as these trials approach, I'll be able to, we'll start going through it and setting up the full picture ahead of time. And I really do want to start building up trial profiles if we're going to be watching a bunch of trials together, which I'm okay with, as long as you guys are. If we're going to be watching a bunch of trials together, then what I want to do is start building up trial portfolios that people can access and start adding in, I guess, tools and things that aren't available elsewhere as easily. We'll start compiling these things and put it out there for people to enjoy. As at first, for sure, it'll be for paid members of the community. It's like a lot of work and investment on my end to start doing this. But once I build it, I think it'll be great. And once I build a system where that stuff can be, where I can create it and host it, and have trusted people contributing to them, and then have people have access to it. I think that's cool. And at some point that might culminate in something like an app similar to like what Emily Baker does. I'm not sure how all of that will work just yet, but I have a lot of ideas about how things should go. I wasn't covering trials as like the main thing before, but it does seem to be a thing people like, and it can be very interesting. I just don't want to get caught up in the trap of everybody's going to cover this trial every single time. I mean, there's certain big public trials where if they happen, I don't care who's covering them. I want to watch them. If Marilyn Manson ever goes to trial, I want to watch that. I don't give a shit who else is watching it. I don't care if it's just me. I would want to watch that trial. I think it'd be amazing. But like, I'm not just going to chase down every media-friendly trial that there is. I'll go crazy. I like finding stuff I'm interested in. This case, an Afro man, 4 days each, beautiful. More of those things. Archiver asked if I'm going to go back to night streams. Ideally, yes. Night streams will still be a part of this channel and a big part of it. But it's all about balancing things out right now. This coming to towards the end of the school year, and then that always changes things. But I do try and still do some night streams when I can. And the other thing I was mentioning was I'm not even opposed to doing 2 trials at a time where we're watching like condensed versions, skipping the breaks and stuff like that. So we're condensing down and doing, one trial in the morning time or daytime and the other trial doing a compressed run through at night. So all of those things are, all these things are possible if you believe. Gen X Medic says, also when I'm wearing my leathers, assholes leave me alone. They might be making correct assumptions about certain items I might have on me. You're talking about your bike leathers. Yeah, well, that's a different story, right? That is a choice. That's not like, oh, I threw on a t-shirt type thing. There's nothing wrong with throwing on a t-shirt from time to time. But I do think a lot of guys could benefit, especially younger guys who don't know about this or who haven't experienced respect from other people yet because you're still young or whatever. I do think there's some benefit to that could alleviate some, or not alleviate, but maybe provide some relief in places that I have heard frustration expressed, is how to word that diplomatically. But I don't want to pass myself off as a hero. I mean, I am the hero of all of these stories, but I'm not here to save the world. I'm just here to complain about it. The judge is not black, Panzer. Very rude. An archiver. Not all of the night streams have been member only, but the night streams making fun of like cooking with Kurt and stuff have been. Those are kind of special. They're specialized. Damn it, Scooter, you're banned. Better a consistent spread out schedule than a jammed chaotic one with kids. I have a consistent jammed chaotic schedule. Okay, we should have just another couple minutes. Tell you what, I'm going to prep one more time, go to the bathroom and pee so I don't have to get up in the middle of the verdict thing. I'm going to play the peeing lawyer song. This song does not mean the show's over. It means I'll be right back. But we have just a couple minutes anyway.
He drank a fair bit and then realized that his bladder can't handle the liquor inside, leaving us with his chair while he runs up the stairs, hoping the stream doesn't suddenly die. While we are waiting, we'll be laughing at you. The drinking along is what most of us do. The chat is united, getting excited for what you have for us when you feel ends and you realize that you've forgotten to scrub both the front and the back. Then you'll grab a quick bite, kiss your lady goodnight, and remember to thank her for all of the snacks. Whoa, water will cure your hangover. Oh, just drink some when the stream is over. When you have slow bladder and no sphincter control, freedom of liquor.
Okay, I'm back. Here we go. What do you want? A charger? Yeah, it's plugged in by my bed. Okay, so waiting for the court feed to be brought back. One minute. We'll see. Chichunia. So, I don't know how to say this in any other way. Children cannot keep track of anything. I have bought so many charging bricks and cables. And they're always like, we don't have charging brick or cable. Like, how do you not? How is that even possible? There's 1,000 of them in the house. Jenny LJ gifted 5 memberships. So did DX Mania 95. Thank you guys. You guys are both very generous, very attractive, very generous, wonderful people, really. Truly the best. We don't hang around any ugly or hideous or undesirables around here. We do need another Chandler Halderson case. I still think his girlfriend took a bite. I think she knew. Why is this still not on? I'm going to just make sure this isn't a product of being on like another channel. I still don't get the lesbians in the topless in the hot tub with Chandler bit of that. Like, I want to understand. Why would you? It's like, oh, your daughter's boyfriend comes over and you're like, oh, yeah, why don't you get in the hot tub with me and my other topless lesbian? And he's like, huh? Yeah, what? Okay. Like, it just, no big deal. I don't trust it. You want someone's parents to be murdered for a new trial? That's metal as hell, bro. I just know it's going to happen, so I'm going to adopt it's happening. Okay, so... We'll, switch feeds because this other one just has other garbage going on. Don't know, don't care about that. Oh my gosh. Apparently judges don't understand clocks. I'd buy a charging table. Say if you can't keep up with your charger, then throw it on the charging table till it's done. Okay, like a wireless charging thing. Aren't those always limited to like a really small space, or do they have them that cover like a whole thing yet? I'm thinking not guilty. It's got to be not guilty, like in my head. That's my head canon is like, I can't imagine it being anything else. Because the way I see this trial, and again, you might even think that she did point the gun at Noonan. But I think the only reasonable thought is that the state hasn't presented the case that she definitely did and that there's not a plausible alternative. I think there is a fully plausible alternative. Here we go.
Good afternoon. We're on record on the Kelsey Fitzsimmons matter, docket 2025, 77 CR 311. All counsel and the defendant are present.
Thank you.
Here we go, guys.
So, before I begin, I'd like to speak to our audience members. I understand that this case has generated a lot of passion and emotion, but you must remember that this is a courtroom and not a sports arena.
No, it is a sports arena, Judge. I checked.
You must not act out emotionally or visibly or audibly react. So you should leave the courtroom if you believe that you will be unable to maintain your composure. I'd like to start with a few introductory words.
We're at 86% not guilty here.
Let me say this. This is not in my script. This has been one of the more exhausting, hardest things I've had to do as a judge.
Really?
Attorney. And
is he crying?
So, as the lawyers know, unlike when a judge presides over a jury waived trial in a civil case, there is no requirement that a judge explain their reasons for reaching a verdict after a criminal bench trial. I do so in this case because I think that Ms. Fitzsimmons, Officer Noonan, and all the people involved in the tragic events of June 30, 2025 deserve an explanation. Next, I'd like to take the opportunity to publicly thank and commend the attorneys in this case. They all did an exceptional job presenting the evidence and conducting themselves in an extremely professional and civil manner. And they did so under the public spotlight in an emotionally charged case. I commend you. To the extent that any of the prosecutors and attorneys may be vilified or subjected to public scorn for simply doing their jobs, in this case, I say that any such scorn is unfair, unwarranted, and simply wrong. These prosecutors and attorneys fought hard but performed their solemn jobs fairly with the utmost civility, and professionalism. They served as a shining example of our adversarial system in operation. Now, I'd like to publicly acknowledge the crucial and often thankless role that police officers perform, a role that Ms. Fitzsimmons herself, like Officer Noonan, willingly and selflessly performed for the citizens of North Andover. For this, you should be thanked, not disparaged. For those that think that serving as a police officer is easy, or that officers don't care or take pride in their work, I say with more than 3 decades of experience in the criminal justice system that you are naive, misinformed, and sadly mistaken. the work of police officers is especially fraught with peril today because of our exceedingly cynical, polarized atmosphere where our citizenry often believes that there is a conspiracy under or around every corner. I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants like Officer Noonan and his fellow officers doing the best they could under tragic, rapidly evolving emotional circumstances. What I also saw was a young woman, Ms. Fitzsimmons,
that does not tell me he's against it. Her.
React to sudden, confusing, and heartbreaking news. Now let me turn to the evidence and the law. Our system of justice requires me to decide this case solely on the law and the evidence. So the only things I have considered in reaching my verdict are the 98 exhibits admitted during the trial and the testimony of the 11 witnesses that testified here in open court. While it may be cold and uncaring, our system of justice demands that emotion, sympathy, and concern for the consequences of my decision play no role in my decision. As for the law, in order to prove Ms. Fitzsimmons guilty of the crime of assault by means of a dangerous weapon, the Commonwealth must prove the following three things. We lawyers call these things elements beyond a reasonable doubt. First, that Ms. Simmons committed an assault on Officer Noonan. Second, that Ms. Simmons intended to commit the assault. And third, that the assault was committed by means of a dangerous weapon. The sole issue before me is whether the Commonwealth proved each of these three elements beyond a reasonable doubt. And more specifically, under the circumstances of this case, the narrow issue before me is whether the Commonwealth proved beyond a reasonable doubt that Ms. Fitzsimmons pointed a firearm at Officer Noonan for any perceptible amount of time. What is not before me are the legality of the issuance of the restraining order to Mr. Alain, the reasonableness of the procedure used by the police to serve the restraining order, the legality of Officer Noonan's use of force, and issues regarding the custody of Caden. It is not my place to decide these issues or even mention my thoughts on them. I am thankful for this because my role has been hard enough. What has made my job especially difficult in this case is that by and large, I found the testimony of Officer Noonan and Ms. Fitzsimmons to be credible on the material and relevant points. In my experience, this is unusual and somewhat perplexing. On the one hand, Ms. Fitzsimmons credibly testified
That's Kelsey.
that she never pointed a firearm.
That's a pro-Kelsey
at
statement.
On the other hand, Officer Noonan testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agree that it happened in seconds near a narrow doorway, and the crime scene photos show
That's reasonable doubt.
the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Noonan's left. The door frame was also made, the door frame was made still narrower when Officer Noonan used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever wrapping the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those circumstances.
Reasonable doubt all day.
However, even if I assume that Ms. Fitzsimmons lied about not wrapping the slide, it does not detract from the adamancy and credibility of her testimony that she never pointed the gun at Officer Noonan, about which he was equally as adamant that she did. Perhaps the Commonwealth could have easily met its burden if the officers had been wearing body cameras. But under these circumstances, I am left with a reasonable doubt, and I am duty-bound to find that the Commonwealth has not met Woo! That Ms. Fitzsimmons committed an assault by means of a dangerous weapon on Officer Newman. And my verdict is, and must be, not guilty.
There it is!
I will hand the signed verdict slip.
Nailed it! I've been saying for days now. Both of them can believe their stories. Both can be true in their minds. But that goes in favor of her.
Ms. Fitzsimmons, could you please stand? On docket 2025, 77 CR 311, count 001. The court having returned a verdict of not guilty, the court orders that you be discharged of this indictment, and this indictment only.
Hell yes!
Kelsey Fitzsimmons, as required by statute. I must inform you that the records regarding the charges for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you may use the request not to seal form posted on the trial court's webpage on mass.gov, or a copy of which I will hand to your counsel. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. You understand?
Yes, I do.
Thank you.
Thank you. Court is in recess. Good? All right.
The right decision.
And thank you once again.
Justice fucking prevails. How refreshing.
Please be quiet on your way out.
You know what's crazy? How can any of the people in the gallery be upset by this outcome? The only person harmed in all of this was Kelsey. Anybody who's like, God, that bitch shouldn't be going free. Why? Cat Black, we have 5 gifted memberships. Thank you so much, Cat.
Folks, make your way out.
Don't risk it. Don't say I love you, Kelsey. Like, you get a contempt charge. Judge said, shut up until you're out of my courtroom. Kelsey was, I think, 100% in the right to pick the bench trial. I think the bench trial may be instrumental in her innocence today. Aw, that was sweet. I assume that's her dad, right? She has been through hell. They took away her bail. They made her actually await this charge in jail, which is
Say that again.
nuts.
Code 1 is also still on, so everybody should be trickling out.
Thank you, Cat Black, for the
So you guys
membership.
want to start going down so that we can get people moving?
Down here from front door, just a second.
Two women. This is Kelsey in the black. This is Courtney. She's a paralegal.
Folks, I don't mean
Great.
to put speed to what you got going on here, but we have other places we need to be as officers. So,
You know, I know some of you have weird connections to Massachusetts and like this area in these cases because of Karen Reed or whatever. If anybody knows Courtney, will you just tell her I love her fucking blue suit? It is so cool. looks great. Her hair contrasts with it. I love that she had, like, every day she has her cuffs rolled back over her, over the edge of her.
That's not on, right?
Suit sleeves. No, it was on.
Amen. Thanks very much.
So I know one of you out there has some connection to her. I could probably message Turtle Boy and ask him to tell her.
See you later.
Absolutely fantastic. It's so cool to see the right result. Not the result we want, not the result that we are predisposed to. It's the result that should happen because she was always not guilty. I don't think she did it. I don't think she raised the gun and pointed it at Officer Noonan. But even if she did, the state just didn't show me that she did. And they could result like the judge said. Maybe the judge may have had a little bit of a personal reason. Body cams solve this. This isn't the first.
Let the word begin.
This isn't the first case that this judge has had to deal with, likely, that would have benefited from some body cams.
Hey, but so DJ7, the Lawrence case.
Noonan is pissed because he lied to the whole world, and you know, the judge tried really hard to pull it back and be like, "Oh no, he wasn't lying," but he was. In my opinion, he absolutely was, and I think the world sees him as a liar. There we go. That's the end of that. Forlorn Tim says, can easily imagine not testifying on wife instability to protect her reputation if one isn't in jeopardy, or even still worrying about it when one is. That doesn't seem to be the case in... that doesn't seem to be the case here, though. Whoops. I just did the wrong thing. Well, I mean, sort of. Let's transition out of this view. I don't know. That doesn't seem to be the case here at all. Justin is safe from Kelsey. He never wasn't. Well, I mean, okay, sorry. Let me correct that. I didn't mean that in the way it came out. Assuming he was being hit by her and all of the stuff happened as he said in the report. Assuming that the moment he's away from her, he's no longer in danger from her, right? Like, he can't go home necessarily, but he can stay away. How this got handled is shocking. Very shocking. They took the words of this guy and we're going to put her in. I don't see a supporting affidavit. I don't see anybody else corroborating the story other than just what he wrote down. The judge took the words of this guy and issued an order without a hearing and without her ability to respond. That's not that crazy if the order says, look, stay 500 feet or 1,000 feet away from this guy. Okay, that makes sense. By the way, you can't have your baby. You can't have your dog. And we're probably going to 72-hour hold you for psych. Wait, what? On just the words of one guy, untested? Seemingly uninvestigated? That's a bit much, in my opinion. But in other circumstances, yes, I agree with you, Forlorn Tim. David says, well, he definitely isn't getting invited to the police Christmas party. Will be interesting to see what happens with this judge, right? Like if any, hopefully he's safe and stuff, but if any career changes happen or disciplinary action or rescheduling to a different bench, any of that stuff. Oh, sorry. Allegedly, Jackie says, who is crying? I think Kelsey was crying and her father, like she was hugging her father and crying. PG says, she said Justin, her fiance, said she punched him closed fist 3 times in the face. I think there would be photos with an injury. I go back and forth on that. Sometimes, sure. In this case, I think so, because he's a sophisticated party when it comes to law enforcement and public service. He seemed to know exactly what he was doing with that affidavit. He knew exactly what to write down. Rumor has it his family is well connected in civil service in that area, which makes me trust them zero. So, let's see. Here we have it. Hold on. We got this will be nice to kind of close things out. We have, get up here. We have a not guilty verdict form from the Commonwealth of Massachusetts signed by Judge Jeffrey Karp. And I do think Jeffrey Karp did a very good job as a judge. Like I said, he kind of grew on me even though it was a short time. And he seemed to be relatively fair. Once those big decisions went defense's way yesterday, I was like, okay, this judge seems to have a grip on things. Those decisions were the type of decisions that, they decided the case. I mean, they decided the factual record. And so those were critical. Once he ruled favorably on those, I was thinking, you know what? At least I think he's for Kelsey, but also, even if he's not, he seems to have done a pretty decent job. There's some weird moments today, but maybe those are just an artifact of bench trials not being so common. He said this is the hardest thing he's ever had to do as a judge, which I find hard to believe. But he normally doesn't have to pay attention to every single piece of evidence, but also pay attention to the legal, machinations going on behind him, or behind everything, I guess. The admission of that evidence. He has to determine if that evidence is admissible. It can be brought into court for his review, and then he has to make his decisions separate from that about what actually happened. All that's very, very incredibly taxing, I would assume, and he seemed to indicate that. I think he did a swell job as a judge in the end. That definitely isn't because he agreed with me. I do want to point out, this is the type of stuff that always happens, and I love it. I love it. If you go back and listen, for days now, I've been saying it is absolutely possible for both theories of this case to have occurred. For Officer Noonan to fully believe that she pointed a gun at his head, and for her to be fully truthful in saying that she didn't, but she pointed a gun at her own head. Both of those things can be true. If they are, you have textbook reasonable doubt. You have two stories that can both exist plausibly from the same factual narrative, not from a different one. All the other, the disagreements between her and Noonan happen after the shot. They happen after he shoots her, which is after the alleged criminal act occurred. So him calling her a whack job, saying I'm the shooter. Up until that moment, she trusted him, handed her baby to him, stuff like that. All of those things build up to this moment. And then that's where things diverge. And he could fully believe that he was in danger. He could fully justifiably respond to that danger and be wrong. But he wasn't on trial. He wasn't on trial. She was. And in that case, if he could have reasonably perceived his own danger and she could have reasonably testified, uncontroverted, that she put that gun to her head and that she wanted to kill herself, if both those stories are true, reasonable doubt. 2 stories, both plausible. 1 criminal, 1 non-criminal. The defendant is entitled by right to the reasonable non-criminal story. And we've seen that not happen in cases that we've watched on this channel. And it happens every day. But that's how it should be. That's how justice gets done. That's what reasonable doubt means. It's sometimes hard to visualize, but that's what it means. 2 stories. Presumption of innocence means that the defendant is entitled to the non-criminal outcome if it exists. All right, guys. Thanks for hanging out. I hope you guys have a wonderful, wonderful day. I'll see, just stay tuned for possible other streaming. I hate to leave when there's, close to 1,000 of you hanging around here on YouTube. And I mean, we've had 300-ish on Rumble all day, which has been fantastic. And keep letting people know that I'm here and that you guys are having a good time in the chat. Please click like on both platforms on your way out and in and out and all of that stuff. And if you guys are watching at home later, please click like. If you somehow made it to the very end, please click like as well. I'll try and get some clipped up stuff and independently produced stuff that's not just clips going. But right now, I got to get to an appointment. Thanks for hanging out with me. And until next time, peace. Hold on. I wasn't ready. I wasn't ready yet. Oh, God. Until next time, peace. Peace.
So pour out another bag about more of that bright. Spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear Lost Planning tonight. From the white shores of Nairn to the hills of Glenlivet, there's no one who explains the plot better than Nick. So pour out a glass for the ones who have